are the plaintiff?
I am the respondent to the first capital suit, and now I am the applicant.
Who's for that dispute? And who's this name?
Mr. Individual is my son.
Immunity minority, we are not even trying to be honest. Records have come, meetings are complete, everything is complete. There is no question of any interim relief in the records. The record is otherwise done. Correct? So you ask your senior, when does he want to do it?
Yes, Your Ladyship. Next week, Your Ladyship. Any date next week will kindly be fixed for you.
Starting with Tuesday. Supplementaries. Take this with me. You have taken the consent from council.
Will inform. ID was already served to you.
Who is the council? So he should not be taken for surprise, no? He will say, I'm not ready. Right? Slip officer. There is a slip, there is a mention in the slip as to whether you have informed the other side, whether you have taken consent or not.
You should just give me a moment, I'll just confirm and let
You
you.
have wasted 5 minutes of hours in the morning. Every day you are mentioning this. Give it to me.
You should have already informed that.
We do not know, you don't even know the name of the council whom you have informed. Because we have to, inform him also that the matter is going to be finally heard. So it's what?
From supplementary race case for orders beautified item Q, first appeal, filing number 2305 of 1025, along with item 3 to 60.
I was praying that the lead case fulfill where we have filed certified copy, that is serial number 90. 1.
Case number?
Case number is filing number will be 2325 of 25.
2325. You have filed a certified copy?
Yes, we have filed, and your ladyship will
Just
file.
2325.
It is placed at serial number
2325.
Yes.
In all other cases, you have filed your certified copy of the award also?
Yes, certified copy of award we have.
In all the cases?
Yes, yes. Now what
You
defect
have the
you
certified copy of the award, बाद में file.
बाद में file किया the presentation.
Just we have prepared a chart, right?
Yes.
In all the cases, this is 2325.
Defect.
Just a moment. There is a defect of court fees.
Yes, that
In the affidavit also
we have
there is a
started
defect.
depositing.
In Vakalatnama also there is a defect. In the litigation petition also there is a lot of defect on court fees.
Court fees to be stamp reporting was done later on.
That's right.
So we have started.
We have done it. Just a
We have deposited for 9. We undertake to deposit within 1 week because we are getting this online court fee when we are depositing it. So in 1 week we will clear entire this court fee check.
Okay, just a minute. Basically, the defect is that the nomenclature in the impugned award.
Yes, now
Is
the
it
check
right?
will come. To the order, what is the defect? I will just highlight.
It will go for correction.
Very small. It has. But what is the defect at page 18? Your ladyship is there at page 18. This bill. The same defect persists or not? Yes.
Yes.
LA. It is written LA case number 495 of 22.
Yes.
Now the concerned defect. at page 85.
It has been written in land reference case.
Yes, page 85.
That is the only
This is the only nomenclature defect that survives land case acquisition case. LA case will be 495 of 22. Instead of it has written land reference case number. So this is the defect.
Now let's figure out how do we expedite.
Now the thing is that we can take all the steps because if we cannot correct it, this has to be done by the tribe.
That's
So the all file has to be.
in all the cases petition for condemnation of the
Yes, there is there in all cases there is petition for condemnation, and in all these cases we have filed this IA
Yes.
for the
exemption from filing the certified copy
site
of the
certified copy in all these cases.
judgment.
Judgment.
But award has to be filed in all.
Award is filed in all cases. In all cases it has been.
Yes.
And authentication fee of 670 to be deposited. We have started depositing. Within one-
Authentication fee for the award
Yes.
and
670 rupees it is coming for all the files. We are depositing it within 1 week. That
from where
exercise.
do you get authentication fee of 670 rupees?
That is the stamp. The certified copy carries 10 rupees with it. So we have given the certified photocopy for that also we are giving authentication.
That's
So it will be standard format for that. 10 rupees per page. Certified copy. So number of pages would be approximately 67 pages are there. So 670. The judgment is 67 pages, so 670 rupees for that. And further, any further amount if it is. Yes. So authentication and code fee.
They have not pointed out the defect of authentication.
But we are depositing it because we
How
know
much
it.
is this?
670, 67 pages are judgment.
7 pages include the award.
No, what we have deposited. Because we filed the certified copy, with that we filed
So
the
67 pages,
670, 10 rupees per page is the authentication.
per page is the authentication. So this also you undertake.
Yes, yes, within 1 week. We are in process, we have started depositing. Like 9 code fee we have already deposited.
Now, in
So
all
this
the
is
cases,
what we have, this is what we have prepared the chart for the fee and code fee and authentication.
सब cases में 24 days delay दिखा.
It will be complete,
हाँ.
a little bit because we have filed in a span of 7 days.
लेकिन इसमें सब में
So we have
24 days delay दिखा.
Yes, yes, so that may be.
You can just have a look at it. आपके लिए कुछ homework करते हैं.
I'm saying great, online speculation.
उन लोगों को बोल के ना आपका without waiting for a certified copy सारा stamp रिपोर्ट
And degree of this, then I take the office report.
हाँ, तो ये आपको हम प्रोवाइड कर सकते हैं बट इट इज योर रिस्पॉन्सिबिलिटी कि इसको डिफेक्ट ठीक है
ये वेरीफाई करना है.
वेरीफाई तो नहीं करना पड़ेगा मेरे ख्याल से लेकिन फिर भी
Because my office is suggesting that we file some, suppose today, then 10 cases we file tomorrow. So it cannot be standard format 24 days.
अच्छा
It has to
you
go.
know, सब में लिखे हैं 24 days delay I do not know we will not say how much delay
Yes,
around
yes.
1 month delay
Yes, 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 that will be indicated.
so we can do one thing we issue notice first would be that you undertake to deposit all the court fees and the authentication
Within 1 week.
First, we have to exempt filing of the certified copy
Yes.
of the judgment,
Yes, yes.
and then we will ask you to deposit all the authentication fee
And code fee.
and court fee
Yes.
and other court fees like there are वकालतनामा में court fee नहीं है ये सब.
That we are all we are undertaking.
Yes, all the
7 days.
Yes.
Wakalatna, we have given in our chart Wakalatnama 50 rupees.
Okay.
In my chart, you will find these are the things with IA for exemption. This is the amount to be deposited. Authentication fee this.
Okay.
Authentication fee with affidavit this. So these all amount we have calculated, and right margin is the total. Right column. All this.
In this IA also the court fees is
Yes, yes, to 280 that we have indicated IA for exemption. Then IA for limitation again 280. That is the fixed format.
ठीक है.
Undertake, I undertake within 7 days.
All these appeals arise out of the same judgment,
Yes.
and therefore they are tagged and are to be verified.
Involving the same issues.
The certified copy of the judgment has been filed in filing
Number two,
number FA 2325 of 2025.
NTPC versus Saraswati Devi Alliance.
NTPC Limited versus Saraswati Devi Alliance. Photocopy of the judgment has been filed in all other
Certified,
cases.
photocopy of certified.
Photocopy of the certified copy of the judgment has been filed in all other cases. And certified copy of the award relating
Respective
to
awards.
all other cases have been filed in the respective cases with authentication.
Yes,
But-
with उसमें
With
authentication. Yeah.
authentication fee on the award.
Correct.
As per the office note, there are sport fees, authentication fee, etc. is what the learned counsel for the applicant has submitted that he shall deposit all the remaining court fees, authentication fee within a period of 1
One.
from today. However, he has submitted that the interlocutory application seeking exemption from filing the certified copy of judgment in all other cases except FA filing number FA 2325 of 2025 be allowed.
Respective IAs are indicated in the list we received that.
Yes, it will take. Upon the state, the learning council for the state has no objection to the plan. And he has further submitted that the authentication fee in connection with the judgment is certainly required to be filed in each case, even if the certified copy is not. Correct? It further appears that in connection with each appeal, except the aforesaid appeal in filing number 2325 of 2025, the court fees in connection with court fees of rupees 280 in connection with IA seeking exemption from certified copy is yet to be deposited. However, considering the stay made by the learned counsel for the appellant, the interlocutory application in each of the case seeking exemption from filing certified copy is hereby allowed, subject to deposit of court fees of rupees 280. This order will be paid.
Yes, yes, 7 days.
Because आपके बिना court fees के भी
I understand. That's why I am saying we have started depositing. Yesterday we have deposited in some matters.
Yes. So far as the court fees / authentication fee in connection with other appeals are concerned, the same be also deposited within the period of 1 framed. At this, the learned counsel for the appellant has submitted that in all the cases arise out of LA cases. But in the award, the case number has been mentioned as land reference case, in connection with which defect has been pointed out by the office. We have submitted that the award is to be sent back to the concerned court for correction. Let the award filed in all these cases be sent back to the concerned court for correction. Ranchi का है?
Hazaripur.
Did you undertake special messenger?
Yes.
Upon deposit of special messenger cost by the learned counsel. It is observed that since all these cases have been tied up together, one set of special messenger cost will be submitted, as he would be taking all the awards at a time.
Grateful.
Okay. Now what else?
Limitation.
If the defects in connection with court fees is removed within the predatory time as directed by this court, let notice be issued in the limitation matter and also the first appeal of all the cases. The delay in filing the first appeals is around 30 days only. Okay. For which recusals be filed by the appellants. कहाँ का है सब?
Hazaripur. अच्छा ये parties भी Hazaripur के हैं।
सब एक ही विलेज है।
एक ही village में।
Through ordinary process and through civil cost. The recusals be filed within 2 weeks from today. Pose these cases on the income cut. It is already. Let the records be called for from the concerned court. बताइए कब करना आपको? आप भी तो हैं?
हाँ इसमें है in lead matter he is appearing and I am appearing 9, 19, 27,
बताइए
37.
कब करना आपको? हमारे पास रहेगा तो हम करेंगे फाइनली.
हाँ
अब बाकी I cannot say.
We wish my lord maybe. NCR otherwise has to be performed.
जनवरी में
और जनवरी में जाएगा.
2 week notice one more time, so it will come first week of February or end of January.
27 January. घूमने जा रहे हैं. 26 जनवरी को तो आप एब्सेंट हो नहीं सकते हैं. इसलिए 27 जनवरी को.
I will.
ठीक है. इन द 27 को नहीं 28 को इन द सप्लीमेंट्री प्रोसेस.
Yes.
तो पता लग जाएगा ना.
सब appearance भी
सर्विस
secure
अपीयरेंस सब क्लियर हो जाएगा. इससे ज़्यादा नहीं कर पाएंगे आप. ये जो इसका जो है ना सॉफ्ट कॉपी बनाया है.
We can also take order 323 that executing court में है वो भी indicate कर दीजिएगा कि trial court service because they are in execution process. So that exercise
अभी कुछ नहीं पता.
और 26
ये वाला जो है हमने जो ये चार्ट बनाया है आपके कन्वीनियंस के लिए आपको यू कैन गेट अ कॉपी। आप इनको आपको सॉफ्ट कॉपी दे देंगे।
सॉफ्ट कॉपी
जब आप डिफेक्ट रिमूव करेंगे ना इस चार्ट के साथ तो मिलान कर
ठीक
लीजिए। एंट्री ऑर्डर्स है ना।
हाँ नहीं अभी तो
इसलिए।
39
और ये भी देखिए हम लोगों ने बनाया है ये भी टेंटेटिव ही हम सबमिट कर तो ये मत बोलिएगा हमें जो चार्ट
नहीं,
मिला था उसमें यही है।
हमने 39 फाइल्स का इंस्पेक्शन कर लिया है।
हाँ।
20 का हुआ नहीं था, अब होपफुली हो गया होगा तो आज हम उसका शुरू
ठीक है इनको सॉफ्ट कॉपी ठीक है। इसको फर्स्ट कॉपी इसमें ये तो यही दे दीजिए ना इसका एक प्रिंट निकाल के इसमें लगा दीजिए।
ये वाला
हाँ,
इससे हो जाएगा
हाँ,
इसको
डीपी वाले
इग्नोरिंग डिफेक्ट का तो एक ही आई था ना वही वाला था एग्जेम्पशन वाला उसके अलावा तो कोई इग्नोरिंग डिफेक्ट नहीं लिमिटेशन में नोटिस कर ये फर्स्ट अप्रैल में भी नोटिस कर ये जो काम हमारा 6 महीना में होना था वो हम कोशिश किए
1 महीना में होगी and they will point out we deposit that special
हाँ ऑफिस टू पॉइंट आउट द आप अपने चले जाइए ना वन सेट देना है आपको क्या करना
नहीं हम पॉइंट कर
अब
from supplementary list of findings to item 1 second appeal 131 of 1998
आपको बताइए कौन सा जजमेंट है आपका?
तीन है लेकिन मेन जो है वो हीरो विनोद करके था उससे अभी लास्ट 2022 में ऑनरेबल सुप्रीम कोर्ट हैज रिलाइड ऑन दैट हीरो विनोद केस व्हिच वाज ऑफ 2006 so that has been quoted and relied and then further it has been so I'm giving a copy हम दे दें copy
ये मेल है यही वाला पेज है चलो हाँ ठीक है आपको एक जगह से बात करना
Para 23, if your lordship would see, para 23 it starts, the discussion starts from there. I'll skip all other portions. Then your lordship may turn to next page, para 29. Hero Vinod. This was the case, actually your lordship, I'm getting a printout of that also. This explains, according to me, very clearly there are three grounds on which the High Court could entertain a second appeal. But here it is quoted. Hero Vinod so and so, this court followed Sir Chundiwala versus Mehta and other judgments and summarized the test to find out whether a given set of questions of law were mere questions of law or substantial questions of law. The relevant portion of so and so, the phrase substantial question of law as appearing in or the amended section 100 is not defined in the court. This word substantial as qualifying question of law means of having substance, inessential, real or sound, worth, important, considerable. It has to be understood as something in contradiction with the technical of no substance or consequence or academic value. However, it is clear that the legislature has chosen not to qualify the scope of substantial question of law by suffixing the words of general importance as has been done in many other provisions. The substantial question of law in which the second appeal shall be heard need not necessarily be substantial question of law of so and so. Then your lordship may kindly turn to the next page. हम 32 से ही 32. To be substantial, a question of law must be debatable, not previously settled by law of the land and or a binding precedent, and must have a material bearing on the decision of the case. If answered either way, in so far as the rights of the parties before it are concerned. So your lordship may kindly take note of the word and must have a material bearing on the decision of the case if answered either way in so far as the rights of the parties before it are concerned. To be a question of law involving in the case, there must be first a foundation for it laid in the pleadings, and the question should emerge from the sustainable findings of fact arrived at by the courts of fact, and it must be necessarily to decide the question of law for the just and proper decision of the case. An entirely new point, so and so I'm skipping. Then your lordship, para 33, the principles relating to section 100 of so and so may be summarized. Then 33(2), your lordship may kindly see. The High Court should be satisfied that the case involves a substantial question of law and not merely a question of law. The question of law having a material bearing on the decision of the case, and the words in bracket your lordship may see, that is a question answer to which affect the right of the parties to the suit would be a substantial question. Then I am again skipping 33 subclause 3 maybe. The general rule is that the High Court will not interfere with the finding of fact arrived at by the courts of law, but it is not an absolute rule. Some of well recognized exceptions are the court below have ignored so and so or acted on no evidence, the courts have drawn wrong inferences of fact from proven so and so, and the courts have wrongly cast a burden on so and so. Then this is one. This is. Then your lordship may, this judgment has earlier also this must have been relied upon. This is a case of Ibrahimuddin. Although this has been referred to for the purposes of Order 41/27, but scope of second appeal, this has been mentioned by the Honorable Court also. And your lordship may kindly turn to paragraph 59. Here the discussion of scope of section 100 starts. I'll skip all other portion, then your lordship may turn to para 63. Para 63. There may be a question, which may be a question of fact, question of law, mixed question of fact and law, and substantial question of law. Question meaning anything inquired, an issue to be decided. The question of fact is whether a particular factual situation exists or not. The question of fact in the realm of jurisprudence has been explained as under, and then your lordship may turn to para 69. There is no prohibition to entertain a second appeal even on question of fact, provided that the court is satisfied that the finding of the court below was vitiated for non-consideration of relevant evidence or by showing the erroneous approach to the matter.
Para 69.
67. 60. There is no prohibition to entertain a second appeal even on question of fact, provided that the
This is
court
very
is
subtle. So, but if a question of fact has a material bearing,
Yes.
that by itself becomes a question of law is not correct. A question of fact may have a material bearing, but by the very fact that it has a bearing in the matter, that does not become a question of law.
Your lordship, if I'll show that if it has been the courts below have wrongly decided a
No, that is
particular,
not a proposed substantial question of law.
but I have said that
No, that is not a proposed substantial question of law. That this finding of fact is perverse. That is not a substantial question of law.
whatever it may be framed, it would ultimately be a question of fact.
Whatever you have suggested, we are looking at it.
Yes.
You see, you suggested that whether this Hussain had 3 wives, namely such and such, or he had 2 wives, namely such and such.
So,
Is it a question of law?
so your lordship, even if it is reframed, let us assume that I'll say
In the case of 1998,
your
we are
lordship
not
may
going to reframe and enter into such exercise.
Your Lordship may allow me to place that fact. I will not say that. Your Lordship, the subsection 105 only says that where the High Court is satisfied. It is not the satisfaction of my advocate or the respondent.
High Court would be satisfied on the proposed substantial question of law that you are proposing.
Your Lordship, I now it is not necessary for me to file an application for the purpose of formulation of
You are
substantial.
filing
If
Once you file an application suggesting further substantial question of law, I cannot proceed with the second appeal unless that is decided.
Your Lordship, I say it in another word. I say that the reversal of this particular finding by the appellate court is perverse.
How do you say this?
I'll show it from the record. If I'm able to show it from the record, then Your Lordship, I'm only drawing Your Lordship's attention.
So therefore, during the course of hearing any substantial, yesterday also after hearing him for 1 hour or so, I framed a substantial question of law. Because I found that there was some perversity in appreciation of it. But once this IA is there, then under such circumstances, unless I dispose of this IA, why should I waste time in unnecessary hearing the entire appeal? Because the suggested substantial question of law does not reveal that it is a question. It is not even a question of law. It is essentially a question of fact.
Ultimately, Your Lordship, this was the reason that I was placing that whatever manner in which ultimately it would be a question of fact. It would be a question of fact. Whether the courts below is perverse or not, absolutely a general proposition. So it is dependent on the pleadings of the parties. We have pleaded. The plaintiff here, Your Lordship may kindly allow me to place the judgment itself, the impugned judgment. And then Your Lordship may start hearing. And then if it is found that this...
So far as this IA and the proposed substantial law question of law is concerned, I am not satisfied. Right? But even if we reject this IA and during the course of hearing we find yes something which is clinching, we can always frame it. But as long as this suggested question of law is staring at me, I will not be able to proceed. You see,
that is not required to be disposed of, Your Lordship. Unless Your Lordship starts hearing, Your Lordship may start hearing. If Your Lordship finds it that this may be rephrased in another manner, then Your Lordship may, because ultimately our duty is only to bring it to Your Lordship's notice that this question that would be ultimately it would be important for the ultimate outcome of the entire litigation. So whatever manner it may be framed, there the suit was filed by the plaintiff. It was dismissed on this particular aspect itself, the ground which I have proposed. And this was the ground on which it was dismissed. And then the appellate court frames a point for determination. This is the point which it frames, and then it reverses the trial court's decree and grants a decree of the partition. So this question, whatever manner it may be framed, this would be there. And we have also prayed for reformulation of a substantial question of law which was already formulated by the Honorable.
which is that reformulation.
Yes. It was formulated on 18/11/1998.
Yes.
अब बढ़ा देना पूरा एक के बाद एक ठीक है 18/11/1998.
Yes.
Whether on death of B.P. Jumrati Khanam issueless the plaintiff in law shall be entitled to a share in the estate left by him.
That's all.
This is. And now what we propose that this may be reformulated is in para 6 we have said. Para 6. That in view of the facts mentioned, the other substantial portion of laws may be reframed as whether in view of plaintiff's own case that B.D. Jograti Khanam had died issueless, sued for partition at the instance of a plaintiff who was a descendant from stepson of B.D. Jograti Khanam was maintained. This is one. Or it can be whether in view of plaintiff's own case that B.D. Jograti Khanam had died issueless, plaintiff in law was entitled to a share in the estate left by him. Now why this is proposed that in
It is same thing, it doesn't make any difference.
Yes.
That alternative which you have suggested.
no
Yes.
why
Whether on death of B.B. Jograti Khanam issueless, the plaintiff in law shall be entitled to a share in the estate left by her.
yes, but in what we propose to say that if in law, in Mohammedan law, stepson cannot be
So whatever
entitled
it
to
is.
inherit.
Whatever it is, if the plaintiff is a stepson, we'll take it as a stepson. Right. So, under such circumstances, this.
We have only added the word when the plaintiff's own case.
How does
that has
see,
been
once the
treated by-
substantial question of law is framed, we will see the plaintiff.
only for the purpose of clarity, otherwise it is not.
It is not required. It's
As
not
a-
required to be reframed.
as-
Whenever I pick up a second appeal, I start with the plain and the written statement. I never take up the facts from the impugned judgment. Unless somebody says that there is, actually what is happening in impugned judgments is there is lot of error in punctuation, there is lot of error in dates.
Yes, that error is.
That error is there and that creates a lot of, it does not reflect clarity in the case of the respective parties. The schedule of the property is not mentioned. The party position is also not properly mentioned. We are not able to figure out whether there was one plaintiff or two plaintiffs, what was their parentage and how they were related to each other. It comes into light only from when you read the play. Without that, it is not possible, at least for me. So therefore, we always pick it up.
So may I pray one thing? Your Lordship may allow me to place, and I'll
No,
still
this
say.
idea I have to do something about it. You see, the proposed substantial question of law, whatever you have proposed, is essentially a question of fact. Nothing is reflecting from the substantial question of law, indicating that it is a question of law also. Forget about substantial question of law. I will simply say that these are the matters relating to facts, and they are not substantial question of law. However, in the hearing, if I find something that I can always bring, I'm absolutely open to that.
Then Your Lordship may, with that observation, I'll withdraw it myself. I'll withdraw it.
बोलने का जरूरत नहीं है.
कुछ बोलने का जरूरत नहीं.
वो
You see, we always
नहीं
look at the
नहीं
details.
वो नहीं because our apprehension may also be seen because Your Lordships have said that I'll look only to the substantial question of law
Naturally, you
which
see,
have been framed.
in the course of hearing, if anything glaring comes to our notice, which we feel that it goes to the root of the matter and there has been glaring error in appreciation. राम को रहीम बोल दिया.
ठीक है
तो ऐसा
ठीक है.
circumstances में तो perverse हो जाएगा.
नहीं ठीक है, even if we are not able to establish that, but at least that particular merit may be
It's
left
always
open
there.
because it is a reversal.
IA number 14490 of 2025. Certain questions of law, certain substantial question of law have been suggested. Certain additional substantial question of law has been suggested, and there is also a prayer for reformulating the question of law as framed by the order dated 18/11/1998. This court is of the considered view that the additional substantial question of law which is sought to be introduced in this appeal are essentially question of facts. And in formulating the additional substantial question of law, there is no indication relating to any error of law committed by the defendants. However, if during the course of hearing, if any material error,
Material comes.
sorry, if any perversity comes to light, then certainly the court can frame a substantial question of law in this court. At this, the learned counsel for the appellant prays for withdrawal of this interlocutory application and undertakes to and has commenced the hearing. Okay?
हाँ ठीक है.
Accordingly, IA number 14490/25 is dismissed as.
Your Lordship, I am also, this is only I'm giving because Hero Vinod case, there are three circumstances, very clearly it narrates the very clear judgment of Honorable Supreme Court. This Your Lordship only keep it, I will not say
Yes,
that.
yes, sure. Give it to me. It is
I am
all
not relying on
immense
this.
use otherwise. Like इसको एक जाति में एडिशन सब्सटेंशियल क्वेश्चन ऑफ लॉ बनते हैं ना, उसमें सब में ये डाल. अब आप हियरिंग शुरू करिए. 98 का मैटर है, अब इसको कैसे खत्म करें इसके बारे में. How much of intricate Muslim law is involved here?
Pardon?
How much of intricate Muslim law is involved in this case?
No,
Not
not much. This is
So
rather
far as
very,
principles of Muslim law is concerned, there is
very limited and straightforward. The other related case that question may arise, but not in absolutely straightforward.
Let us see the plain and the written statement.
Yes.
And whatever you wanted to say
Yes.
that is admitted, you can highlight that.
Yes.
ये देखो. ये सब एक साथ बंद बना दो. Second text. Plain.
Main dispute is genealogy. Very clear genealogy relied by plaintiff and the defendant. Very clear point where we are disputing and they
इसमें मांगा गया था हम लोग से रिटर्न
हाँ,
वो सब
आपने
दे
दे
दिए.
दिया?
जी जी जी.
नहीं इसी में प्लेन से
Written submissions दिए हैं.
नहीं
सर आप भी हैं इस केस में?
हाँ सर है सर ही लीड करेंगे
हाँ,
और
थोड़ा गला खराब है मेरा. इसलिए हम इनको बोले कि आप ही करिए.
कोई बात
नहीं हम इसी में नहीं करते.
सर आप हैं ही तो कोई क्या बात है. आप कोई भी बात हो तो आप बोल भी सकते हैं.
हम लोग दोनों ही हैं.
मैंने बहस शुरू करी. जेनियोलॉजी जो है
सर
लोअर एपलेट कोर्ट ने उसको भी डील किया है.
हाँ ठीक है.
अब क्वेश्चन भी वही फ्रेम किया है.
हम काउंसिल की बात करें.
जी.
हम very clear I'll place the genealogy placed by the plaintiff itself so that no dispute arises when I'm placing the genealogy.
Plain.
Plaint your Lordship may first see genealogy and then plaint may be seen. It is in second page. Genealogy is in second.
paragraph 3.
The
कहाँ डिस्प्यूट है बताइएगा. आप लोग साथ आप दिख नहीं रहे सर.
हम बता दे रहे हैं हम क्लियर
सर आप उधर साइड में मत बैठिए. आप सामने बैठिए.
अच्छा सॉरी.
हम ही बता दे रहे हैं बहुत क्लियर
हाँ बताइए.
इनका
ये मिर्जा विलाय सर.
हाँ
सर ये जिनोलॉजी में आइए. प्लेन है आपके पास.
जी.
हाँ.
और सर्टिफाइड कॉपी ऑफ दी ताकि हम बोल देते हैं कि हमारा सारा फाइल खो गया था. सारा हम हाई कोर्ट से ही नकल निकाले.
ठीक.
इसे नकल है हमारे पास.
अब आप हमको बताइए इस जिनोलॉजी में कहाँ डिस्प्यूट.
हम बता दें हुजूर.
सर उनको बता दीजिए. उनका
हम
अपील है.
बता दे रहे हैं
आप क्यों परेशान हो रहे हैं. आपकी बारी आएगी. आप चिंता मत कीजिए.
इसमें मेन जो है इनका इस्टेब्लिश करना था वही तो हम लगाए थे रिजॉइंडर हुजूर के सामने काउंटर एफिडेविट उसी का दिए हुए थे।
देख लेंगे
इसमें जो डिस्प्यूट ही पैदा करना चाह रहे हैं
अब
इसमें
हम
क्या-
मेरा अपील है
सर आप
अपील कहाँ विड्रॉ कर रहे हैं, अपील तो बहस कर रहे
नहीं,
हैं।
हम
अभी बहस कर रहे हैं ना, करने
ठीक
दीजिए।
ठीक
अशांति से हमको कोई हड़बड़ी नहीं, आपको दूसरे कोर्ट में जाना है क्या?
कहाँ से हड़बड़ी होगा?
आपको दूसरे कोर्ट में जाना है?
ना ना, अब ज्यादा भी होगा तो आपका कोर्ट छोड़ कैसे दूँ?
ठीक है।
and I'll
छोड़िएगा
try
तो
to be
नुकसान में
fair.
रहिएगा।
I'll try to be fair and
हाँ यस
Your Lordship may
बोलिए।
Your Lordship may see undisputed fact that Mirza Vilayat Hussain was the common ancestor of the party. Now the dispute is amongst the wives of who were the wives of Mirza Vilayat Hussain. Here the entire dispute is there. Plaintiff's case is that Mirza Vilayat Hussain had three wives. First wife was Vilayatul Nisa, and the plaintiffs are descendants of Vilayatul Nisa. This fact of the genealogy is not in dispute. That the plaintiffs are descendants of Vilayat Hussain from the first wife.
Just from first
Both sides are not disputing this.
not
Yes. That plaintiffs are
okay.
plaintiff and pro forma defendant, they were descendants of Vilayat Hussain from the first wife, namely Vilayatul Nisa. Now, entire dispute is between second and third. Their case is that we, the defendant appellant, were from the second wife, Firoza Khan. Defendants were descendants from the second wife, namely Firoza Khan.
Just defendants are descendants from second wife.
From second. And third wife was died issueless. This is their case. Property undisputably involved in the instant suit be recorded in the name of Jumrati Khan. This is undisputed. Third wife. Our case is that Vilayat Hussain had only two wives. There was no such wife named as Firoza Khan. And
Only two wives.
two wives.
And no
That
wife
means Vilayatun Nisa and Jumrati Khanam, these were the only two wives of Vilayat Hussain.
So you are disputing your your own genealogy
Yes, yes, yes.
as given in the plain.
Yes.
So you fall under
I say-
which wife?
Yes, our case is that Jumrati Khanam did not die issueless, rather she died leaving behind son Mirza Jainuddin Hussain, and the plaintiff are descendants of Bibi Jumrati Khanam. And there was no such wife as Firoza Khan.
Your case is
Yeah.
that since Bibi Jumra, since you are descendant through Bibi Jumrati,
Yes.
so you by matter of right
Absolutely.
inherit,
This is the
and your
entire.
status is not that of a stepson.
Yes, yes, yes. This is our entire case.
यही
Entire.
झगड़ा है सर?
इसका फाइंडिंग जो है
नहीं झगड़ा यही है ना?
झगड़ा यही है,
ठीक।
लेकिन डॉक्यूमेंटरी एविडेंस से आ गया है
आएंगे ना, अभी आने दीजिए ना, लेकिन
जो कि हम
पहले-
लगा दिए।
पहले झगड़े की जड़ को तो समझने दीजिए।
नहीं तो इसी के बारे में ये जेनोलॉजी का डिस्प्यूट पर भी ऑनरेबल सुप्रीम कोर्ट ने एज फार बैक एज इन ईयर 1981 हैज आंसर्ड इट एंड यू लॉर्डशिप मस्ट हैव द
पहले हम अपनी बहस करेंगे सर, उसके बाद
अभी रुक जाइए,
थोड़ा सा
प्लीज होल्ड ऑन।
मौका दे दीजिए बस।
अरे यार केस तो लड़ने का इनका ऐसा चीज हुआ है ना हुजूर इस केस में, इसका वर्णन देखा
I object to all these statement made by learned senior.
सर जो चीज रिकॉर्ड से नहीं है उसके ऊपर
Irrelevant to the appeal.
Learned Counsel for the appellant has submitted that the appellants are the contesting defendants in the suit. Lost in both the courts?
No, the trial court had dismissed the suit for partition.
The trial court dismissed the suit for partition and the first appellate court reversed the findings and allowed the suit for partition. He submits that it is undisputed that the common ancestor is Mirza Vilayat Hussain. As per the plaintiff, he had 3 wives. Bibi Velayatul Nisa, within bracket first wife, Bibi Firoza Khanam, within bracket second wife, Bibi Jumrati Khanam, within bracket third wife. It is the learned counsel submits that as per the case of the plaintiffs are the descendants through Bibi Vilayati Nisa, and the contesting defendants are the descendants through second wife Bibi Firoza Khanam.
According to plaintiffs.
According to plaintiff. Further, admittedly, the suit property stands in the name of Bibi Jumrati Khanam, and as per the suit, as per the plaint, third wife Bibi Jumrati Khanam died issueless, and the entire dispute relates to partition of the property standing in the name of Bibi Jumrati. The learned counsel for the appellant has submitted that the core dispute in connection with genealogy in this case is that the contesting defendants claim that there was no wife, namely Bibi Firoza Khanam, within bracket the so-called second wife, and the contesting defendants are the direct descendants through the third wife, through Bibi Jumrati Khanam, in whose name the suit property is standing. He submits that if that be so, then the entire property would naturally devolve upon the direct descendants of Bibi Jumrati Khanam and descendants through first wife, namely Bibi Vilayatu Nisa, who are the plaintiffs before this court, would have no right title interest over the suit property. This is the entire dispute.
Entire.
Okay.
And therefore, your Lordship may see that they pray that your Lordship may see cross title and then prayer. That the plaintiff prays for following reading: a preliminary decree for 4 annas share be passed in favor of plaintiff out of the suit land. Why he is seeking 4 anna is because there are further 2 branches, and he is seeking 4 anna for herself, plaintiff, and 4 anna for defendant number 2. Defendant number 2 and yes. So 4 anna for plaintiff, 4 anna for pro forma defendant. So total becomes 8 anna, and 8 anna for us. That is the prayer. that after passing a preliminary decree, final decree for 4 annas may be passed and so on.
The suit was filed.
Your Lordship, para 7 में kindly this particular statement that Musammad Kamjadi also died in so and so, in Mahmud Alam died on so and issueless leaving behind 2 sisters, the plaintiff and defendant second party who jointly came in possession of respective share with the defendant first party, the share of the plaintiff 4 anna and 4 anna share of the defendant second party and 8 anna of the defendant.
The learned counsel has
Six को भी जरा सा देख लीजिए.
अभी देखिए, the learned counsel has submitted that as per the plaint, 4 anna share would go to the plaintiffs, 4 anna to the defendant second party within bracket pro forma defendant, and 8 anna to the defendant first party within bracket contesting.
Defendant anna.
What the appeal.
So this is the entire case of the plaintiff. Now our case is
उसके बाद है paragraph 8 पे किया जाएगा. If there were no male member in the family of the Amrunsa,
उस सब में dispute नहीं है, कोई dispute नहीं. अगर dispute है तो
उसको कम से कम
I'll read it. I'll only to
dispute कहाँ पर है वो देख रहे हैं. बाकी तो सब admitted है कि मेल मेंबर नहीं है, ये सारी चीजें admitted है ना.
I can read the entire unnecessarily I'll be wasting your lordship's time. Therefore, and my learned senior counsel would get an opportunity to reply to my.
ठीक है भाई, ठीक है. आपका आप ही को मदद करते हैं. आप ही को मदद करते
हम टाइम बचाने के लिए कर रहे हैं. हमने तो 10 दिन आगे कर रहे हैं.
हाँ बताइए और आगे क्या.
My written statement may kindly be seen here. Lordship. Para 10.
Yes,
This is the genealogical table given in para 3 of the plaint is not correct. It is false to say that Mirza Vilayat Hussain had 3 wives. In fact, Mirza Vilayat Hussain had only 2 wives, Bibi Jumrati Khanam and Bibi Vilayatul Khanam. It is also false to say that Mirza Vilayat Jainuddin was born of Bibi Firoza Khanam. The fact is that Mirza Jainuddin was born of Jumrati Khanam. Mirza Vilayat had only 2 wives, namely Bibi Jumrati Khanam and Bibi Vilayatul Khanam. He had no wife named as Firoza Khanam. In fact, this has also been admitted by Amjadi Begum in Swans. And we had given a genealogy of our own, where we say that Jumrati had died issueless, died leaving behind Mirza Zainuddin, and then he died leaving behind
only the name of the mother changes.
Mother. And then the para 11, that the statement made in para 4 of the plaint is correct to the extent that the suit land is recorded. Yes, can I place it from the judgment itself?
Yes.
Now, if your Lordship would see the trial court judgment, these facts have been mentioned by the trial court. The para 4, the defendant first party appeared and filed their written statement, and then next page after formal objections, after 4, 5 lines, the suit is land is exclusive property of defendant first party and he is in possession of the
We
suit.
just come to that judgment.
Trial court judgment, para 4, where my written statement has been put. and relevant is after 4 lines from the top. The suit land is the exclusive property of the defendant first party and he is in possession of the suit land. The defendant first party have admitted that the suit land is recorded in the name of Jumrati Khanam and they are governed by Shia School of Mohammedan law. The defendant has also admitted that Mirza Vilayat Hussain was the common ancestor of the party, but they have denied that he had 3 wives. The defendant first party's case is that Mirza Vilayat Hussain had only 2 wives, Bibi Jumrati Khanam, Bibi Vilayatun Khanam, and Mirza Jainuddin was born of Jumrati Khanam. Mirza Vilayat Hussain had no wife named Firoza Khanam, and these facts have also been admitted by Amjadi Begum in RM case number 209/76 of the Court of SDO Gota. Yeah. This we have referred to the earlier by their predecessor in interest.
They are governed by Shia law.
They had said
They are governed by Shia law.
yes. Mirza Vilayat Hussain had no wife, namely Firoza Khanam, and these facts have also been admitted by Amjadi Begum in RM case number so and so of the Court of SDO Gota. Amjadi was predecessor in interest. The defendant first party has mentioned in the genealogical table in his written statement, and according to their genealogical table, plaintiff and defendant second party are the heirs of Vilayatun Khanam and defendant first party are the heirs of Jumrati Khanam. The defendant first party has denied that Jumrati Khanam died issueless. Jumrati Khanam died in 1942 and after her death, her son Mirza Jainuddin died sometime in the year 1945, leaving behind his son Mirza Abid Hussain, the defendant first party. Then your Lordship may kindly skip 4-5 lines. Now, we have अच्छा हम पूरा ही पढ़ देना. It is also false to say that the death of Bibi Jumrati Khanam and her property came in joint possession of Bibi Amirun Nisa and Mirza Abid Hussain. Bibi Amirun Nisa and or her mother Amjadi Begum never came in possession of the land recorded in the name of Bibi Jumrati Khanam. Bibi Amirun Nisa died leaving behind her mother and 3 daughters, but they never came in possession of the suit land either jointly with the first party or separately, nor they had any share in the suit property. The plaintiff's second party and Amirun Nisa never came in joint possession of the suit land and hence they have no share in the suit property. The suit property is exclusive property of defendant first party. So this was our specific denial. Then your Lordship may kindly turn to next page. Next page, there was a collusive title. No, I'm skipping that. Then issues, your Lordship may see. Issue number 4 is whether have the plaintiffs got any right title interest, right title possession and share over the suit. Your Lordship has got the issue.
Yes. Issue number?
Yeah, 4.
This is the issue?
That is the main issue. Main issue. Entire case would revolve there. Have the plaintiffs got any right title and possession and share over the suit? Then finding starts from para 6, issue number 4. First few lines may see and then I'll skip. This is the main issue of the suit. It is admitted by the parties that the suit land is recorded in the name of Jumrati Khanam in the last survey settlement. It is also admitted by the parties that Mirza Vilayat Hussain was the common ancestor of the parties. The plaintiff's further case is that Mirza Vilayat Hussain had 3 wives, namely Bibi Vilayatun Nisa, Bibi Firoza Khanam and Bibi Jumrati Khanam. Bibi Jumrati Khanam died issueless and after her death, her property, that is the suit land, revolved on the heirs of Bibi Vilayatun Nisa and Bibi Firoza Khanum. Plaintiff and defendant second party are the heirs of Bibi Vilayatun Nisa and the defendant first party are the heirs of Bibi Firoza Khanum, and the plaintiff and defendant second party have 4 owners share each in the suit land and 8 owners share belongs to defendant first party. Contrary to defendant first party's case is that Mirza Vilayat Hussain have only 2 wives, namely Vilayatun Khanum and Bibi Jumrati Khanum. Plaintiff and defendant second party are the heirs of Bibi Vilayatun Khanum and defendant first party are the heirs of Bibi Jumrati Khanum. Then your Lordship may kindly skip to the next page. May I read the entire or?
No, whatever you want to
Yes,
say.
yes. Your Lordship, then next page, para 7, PWs were examined and PW witnesses he refers that PW1 is the son of Karpardar of the ancestor of the parties who narrated the case of the plaintiff in the examination in chief, and then in cross-examination he admitted that he deposed in several cases of the plaintiff. On perusal of his cross-examination, it appears that this witness is a professional. PW4 has stated so and so that both parties have cultivated the suit land, and again after 4 or 5 lines after discussion he says that this witness is not competent to depose regarding the possession of the parties. And the defendant PW5 has stated that the suit land is not separated but the parties are cultivated separately. On perusal of the cross-examination of this witness, it appears that previously he has deposed in favor of plaintiff in other cases and he is a bailer of a son, Muna Alam, in criminal cases. In this way, this witness appears to be interested one. PW9 is the husband of the plaintiff who narrated and supported the case of the plaintiff, and in this cross-examination in cross-examination he has admitted that his father and mother were Sunniya Mohammedan and later he converted in Shia Mohammedan. The learned counsel on behalf of so-and-so submitted that this witness is a greedy so-and-so and he converted so-and-so. I'm skipping all those portions. Then my defendants first party have examined altogether 9 witnesses. Para 11, DW6 and DW7 have deposed in one voice that Bibi Jumrati Khanum was the second wife of Mirza Hussain. She had one son, namely Mirza Jainuddin Hussain. Mirza Jainuddin Hussain had one son, so and so. Mirza Abid Hussain had one son, namely Shakir Hussain, and 2 daughters, namely so and so. And then your Lordship may kindly skip and then paragraph 12. DW8 is the present defendant who has narrated and supported his case in examination. In cross-examination, he has stated that title suit number so and so was filed between Vilayat Hussain and 2 wives. Para 13. 13 onwards, your Lordship, I'll read it.
Yes.
On behalf of the plaintiff, Exhibit 1, bail petition, Exhibit 2, signature of typist on bail petition, Exhibit 3, signature of typist on plaint of title suit number 285, Exhibit 4, amendment petition, Exhibit 5, power of attorney, Exhibit 6, series of parcha, Exhibit 7, series mistake list, Exhibit 7, series rent receipt, Exhibit 9, certified copy of judgment of title suit number 285, Exhibit 10 is the certified copy of judgment of civil appeal number so and so, and Exhibit 11 is the certified copy of decree of appeal have been filed as documentary evidence. The learned counsel on behalf of the plaintiff submits that in title suit 285, Mirza Abid Hussain versus Sapra Hussain, the defendant first party has admitted Mirza Vilayat Hussain had 3 wives and Jumrati Khanum died issueless. That title suit was decreed in favor of Mirza Abid Hussain by the learned son. So here I pause, Your Lordship. This is the second suit of which the appeal is still pending. This is so the contention of the other side was that in this particular suit we had admitted that he had 3 wives. Now the subsequent discussions
Appeal arising out of this suit is also pending.
pending before your lordship. It was already there.
We have taken the examination.
Yes, that additional question of law was formulated by your lordship that they have taken time and the matter will be fixed on January. But
They are going to challenge. Have you challenged that order?
Yes.
आप challenge कर दिए?
The Supreme
so why this? What is the relevance of this? That your lordship, both the trial court, the other side, that means the plaintiff, they are relying that we have admitted in that particular suit that Mirza Vilayat Hussain had 3 wives.
The plaint that suit has been.
Plaint, yes, plaint
Has been exhibited.
Plaint had been admitted, and
Who
the
was the
judgment
plaintiff in
also.
that case? Who was the
But
plaintiff?
this particular plaint is our suit was there. We had filed the suit. The admission is not there in the plaint. The admission which the other side is relying on is contained in the judgment, and this says that it is our case so and so. It mentioned, but no such statement is there in the plaint. This is our content. That when the plaint itself was there, the appellate court, while referring to our case, could not have said that we have said so and so that there are 3 wives. And what would be the consequence of that? Which would
So in the earlier suit, the court has committed some error in recording.
yes. And the first appellate court says that despite that error being there committed by the court, we did not file an application for getting it corrected. That is the observation of the appellate. Now, my reply would be absolutely simple. With regard to when the said matter was being contested, the matter has to be only decided on the basis of what was there. Dispute was. This particular fact, wrongly recorded, was not affecting us in that sense. So we could not
Every
reply
fact
to
which
have.
is wrongly
It was
recorded
absolutely
need not be challenged.
Yes.
Because that was not a finding of fact
No,
given in that case.
no, absolutely.
There was no dispute as to how many wives and how
No,
many
in that
sisters.
suit the dispute was not there. But the appellate court, when the plaint itself is there on record, it relies on that judgment and says,
चैलेंज था उसमें जनरली ही डिस्प्यूट था
I'm sure all these things I may be allowed to.
नहीं ठीक
हम
वो
बता
रहे
देंगे।
कहाँ है वो
हमको गलत ही सही हमको प्लेस करने दीजिए हम।
गलत का है हम भी गलत नहीं करेंगे
Now your lordship, I'm not sure whether your lordship's report is same. I have also have a certified copy.
इसमें और जरा सा
पैरा 13 का 13 में the trial court is starting discussion on perusal of exhibit 3 and 4. It is my there
Half
in
of the plaintiffs are on perusal of exhibit
3 and 4.
and this in the impugned judgment, no? In the trial court's judgment.
A trial court judgment. In my copy, it is in page 13, which I am referring. But your lordship, it is part of paragraph 13. Paragraph 13, approximately, it would be 20 lines of paragraph 13.
On perusal of
On perusal, exhibit 3 and 4, it appears that defendant first party have mentioned a genealogical table in the plaint of title suit number 285, in which defendant first party have not clearly mentioned that Mirza Vilayat Hussain had 3 wives. So it is discussing my claim. On perusal of exhibit 7, series mistake list, it appears that there is no clear admission that Mirza Vilayat Hussain had 3 wives. Exhibit 1 is the bail petition. On perusal, it appears that defendant Mirza Shakir Hussain had mentioned that Jumrati Khanam in his bail petition, but there is no statement that Mirza Vilayat Hussain had 1 wife, Jumrati Khanam. In exhibit 9 and 10, this is the exhibit of judgment. 9 and 10, there is inclusion that Mirza Vilayat Hussain had 3 wives, But there is no finding on this point. However, it is a settled principle of that to get a degree, the plaintiff must have proved his case. The plaintiff cannot take advantage of the mistake of the defendant. As stated above, the witnesses of the plaintiff have not been able to support the plaintiff's case. Therefore, the above submission made by the learned counsel on behalf of the plaintiff will not help the plaintiff. The learned counsel on behalf of the plaintiff submits that on behalf of the defendant first party have not cross-examined PW1 and 9 on the point of wife and son, hence this amount of admission by the defendant first party. In support of so and so, he relies on so and so. On perusal of cross-examination PW1 and PW9, it appears that these witnesses have been cross-examined on the point of wife and son. The clear case of the defendant first party that Mirza Vilayat Hussain had only two wives and the defendant first party are the heirs of his second wife Jumrati Khanum. On perusal of above referred ruling, it appears that the fact that the ruling is different from the present case, therefore above ruling will not help the plaintiff. The other document filed on behalf of the plaintiff will not help the plaintiff. On behalf of the defendant first party, Exhibit A series, rent receipt so and so, Exhibit B RN case number 209 of 76, SA appeal number so and so, RP SA ground and Exhibit C series are signatures of on Exhibit D. The learned counsel on behalf of defendant first party submits that Exhibit D RM case number 209 of 76 has been filed by Amjadi Begum, Nani of the plaintiff, against Mirza Abid Hussain, in which she admitted that Mirza Vilayat Hussain had two wives, Jumrati Khanum and Vilayatun Khanum. Hence, there is no dispute that Mirza Vilayat Hussain had only two wives. The learned counsel on behalf of the plaintiff submits that statement made by Amjadi Begum is not binding upon the plaintiff. It is correct that the statement of Amjadi Begum is not binding on the plaintiff, but the Amjadi Begum is the Nani of the plaintiff and the plaintiff is claiming her right through Amjadi Begum. Therefore, statement is claiming her right through Amjadi Begum. Therefore, the statement made by Amjadi Begum cannot be overruled. Exhibit A series are the rent receipts which prove that the dependent first party have paid the rent of the suit land and they are still paying the rent for the same. Considering the witnesses adduced by the parties, fact and circumstances of the case, and so in so discussion, it appears that the plaintiff has not been able to prove her case. Accordingly, I find and hold that the plaintiff has no right, title, possession, and share of the suit land, and then it dismisses the suit for arbitration.
Privately recorded a finding that he had only two wives.
No, yes.
And what about the first appellate?
Yes. First appellate court has again quoted the genealogy. I am skipping all those. Your Lordship may directly come to the point for determination at para 9, which was formulated by the para 9. Para 9.
Yes.
In view of the contention of the party, the following points arises for consideration in this appeal. Whether Vilayat Hussain had three wives, Bibi Vilayatun Nisa, Bibi Firoza Khanum and Bibi Jumrati Khanum, or had only two wives, Vilayatun Khanum and Bibi Jumrati Khanum, and whether Mirza Jainuddin was the son of Bibi Jumrati Khanum or Jumrati Khanum died issueless. So this was one of the points, and whether the plaintiff appellant has got unity of title and possession over the suit land. Point number 1, it starts the discussion, and I place the portion for which I was saying that the substantial error was committed by the applicant? That directly, if your lordship would see, in my page it is 18, after genealogical table has been mentioned, there is a very short genealogical table has been mentioned.
Yes.
And thereafter, para
It
16,
appears that.
para 16.
Yes.
It appears that Abid Hussain, the original defendant of the present case, had filed title suit 285 against the plaintiff appellant Sabra Khatun and her sister Bibi Mehrun Nisa, praying for declaration that the suit property belonged to him and defendant have got no means of right title interest over the same, and they are not entitled to take delivery of possession of that in execution case number 5 of 1980, arising out of title suit number 6 of 1976. After the death of Abid Hussain, the present respondents were substituted as a plaintiff in place of Abid Hussain in that title suit number 2/85. Exhibit 9 is the judgment of that title suit number 285. From perusal of para 3 of exhibit 9, it appears that the plaintiff of that case, respondent hearing, made out a case that Mirza Vilayat Hussain had 3 wives, Bibi Vilayatul Khanam, first wife, Bibi Firoza Khanam, second wife, and Jumrati Khanam, third wife, died issueless. This is statement fact is carried in para 2 of exhibit 10, that is judgment in title appeal number so and so. Further, exhibit 9 and 10, it appears that it was the case submitted before the court that first wife Vilayat got a son Mirza Yusuf, and from second wife a son Mirza Jainuddin. From the above, it becomes clear that these are the statement of admission in judgment between the same parties, and it is admissible under section 18 of Evidence Act. There is no explanation to this statement of admission of fact in exhibit 9 and 10. It is well settled of law that admissions, unless explained, furnishes the best evidence. The learned counsel for the appellant cites so and so. The lands of that suit are not the subject matter in this suit. On 1/4/1998, the learned counsel for respondent has filed an application praying that the original record of title suit number 285 may be called for from the Honorable High Court for verification of exhibit 3 of the plaint of so and so. This was irrelevant. Why? Because it was already there on record. It appears that this appeal was heard on different dates.
So the case was decided on account of admission.
Yes, on account of admission, and it says that
Recorded in the judgment.
it recorded in that. But
But
it's
in fact recorded in the judgment which was contrary to the plaint.
and the appellate court also mentions that exhibit 3 is the plaint which is already there in record and it is very much legible, and therefore our contention to call for record was not required. So it rejects that. But once the original plaint itself was
Let
there
us
on
see in
record.
the original plaint, is there any admission?
No. The appellate court says so. I'll read out there. हमको उसको पढ़ने ही दीजिए पूरा वो डिस्प्यूट यहीं से क्लियर.
Let us clarify ourselves on the point of law in this connection. Suppose in a plaint, a person writes something, and that issue does not fall for consideration. That is not the issue before the court. And it is finally recorded in the judgment. Something else is recorded in the judgment. Then the recording in the judgment will be taken as admission, or it will be taken as erroneous recording in the judgment. So मान लीजिए आपने बहस किया, आपके रिकॉर्ड में लिखा है कि वो उसका भाई था, लेकिन फाइनल जजमेंट में लिखा गया कि वो उसका नहीं, वो उसका भाई. फाइंडिंग में नहीं लिखा है, फैक्ट में लिखा है, डायरेक्शन ऑफ फैक्ट्स. अगर मान लीजिए किसी जजमेंट में कोई फाइंडिंग आ जाता है ना कि भाई वो उसका भाई था, दैट इज अ सेपरेट थिंग.
इसमें एक चीज जो प्रोमिनेंट हुजूर के सामने आया, वो प्रोमिनेंट चीज क्या है? डिस्प्यूट एक ही चीज का है कि डिफेंडेंट tried to establish कि विलायतुन जो थे
उनकी दो ही बीवी।
उनको दो ही बीबी थी, और दो बीबी कहने में ये जो इसमें डिफेंडेंट है इनका ये कहना रहा कि दो ही बीवी थी और उसमें एक का वो लड़का है। वहाँ जुमराती खानम जो है तीसरी वाइफ, जिसके नाम से प्रॉपर्टी था, उसी के प्रॉपर्टी का ये झगड़ा है, उसी में हम 4 आना क्लेम करते हैं। तो उसमें वो उस चीज को डिथ्रोन करना चाहते हैं कि नहीं हम उसका लड़का है, जबकि फैक्ट ये है उसको शी डाइड इशूलेस। अब हमको प्रूफ करना है, इसमें ट्रायल कोर्ट का जजमेंट मेरे मित्र ने पढ़ा, लॉर्डशिप हैज सीन बट ही हैज नॉट डेल्ट द डॉक्यूमेंट्री एविडेंसेस व्हाट द डॉक्यूमेंट्री एविडेंसेस स्पीक। इसमें खुद उनका एडमिशन है, किसका, वो आबिद हुसैन का, कि मेरी माँ अलीमन थी। इसी के
कौन सा डॉक्यूमेंट है बताइए।
हाँ 7 और 7A
कौन सा डॉक्यूमेंट है खाली बताइए कि इनका खुद का एडमिशन है।
जी जी बिल्कुल उसका
इनकी
एडमिशन।
माँ का नाम अलीमन।
जी।
क्या अलीमन थी थर्ड वाइफ का नाम?
अलीमन was the mother of wife of Jainuddin, mother of Abid।
दिखाइए कौन सा डॉक्यूमेंट, which document is clinching on this issue?
जी ये है,
Exhibit
हम
number?
जो रिजोइंडर फाइल किए हैं,
Exhibit is under exhibit।
एग्जिबिट
हाँ,
7 and 7A
लाइए exhibit।
इसका एडमिशन है, दूसरा स्कोप कहाँ है, इसका बहस का स्कोप नहीं है। क्या है कि ये हमारे जेनोलॉजी को डिसबिलीव करना चाहते हैं, इसलिए कि ये सारा प्रॉपर्टी हड़पना चाहते हैं। यही खेल है, केस यही, इसमें इतना ज्यादा कुछ नहीं। इसका सर्टिफाइड कॉपी हम हाई कोर्ट से ही निकाले थे। मिस्टेक लिस्ट, इसको हम लगा
मिस्टेक लिस्ट क्या होता है सर?
मिस्टेक लिस्ट जो हुआ हुजूर, जो जेनोलॉजी जो ये हो रहा था, गेंजर सेटलमेंट हो रहा था
उस समय का mistake।
उस समय का, उसमें इन लोगों में पारिवारिक हुआ, क्योंकि जैनुद्दीन जो थे फादर ऑफ आबिद, ही हैड गॉन टू जेल, किसी कारण से जेल चले गए थे, तो इसीलिए परिवार में हुआ, कितना परिवार है आपस में मिलकर के सबों ने एक वहाँ मिस्टेकली वहाँ दरखास्त दिया कि इस तरह से किया जाए, उसको करेक्शन किया जाए इसी तरह से प्रॉपर्टी के बारे में। और उसी में जो है बड़ा जबरदस्त चीज है, उसमें जुमराती खानम का अलग है और अलीमन का अलग है, उसमें इनका स्टेटमेंट है, पाया गया उसको।
हाँ 7/8
7 7 1 7 इसमें देखा जाए, इसमें लिखा
7/1 तो मिला।
7 होगा 7/8। हम दोनों को हुजूर सर्टिफाइड कॉपी का फोटो कॉपी लगा दिए हैं सुविधा के लिए अपने रिजॉइंट काउंटर में।
अच्छा
जैसा देख लिया जाए जो दिए हुए हैं, हम जो फाइल के इनका काउंटर जी उसी से देख लिया मिला। प्रेजेंट जो आई है ना उसी का रिजॉइंडर फाइल
Annexure 1 जो आपने
1 and 1A
1 and 1
One। इसमें है एक्सट्रैक्ट ऑफ द मिस्टेक लिस्ट ऑफ मोजा गोड्डा टाउन 502 रजिस्ट्रेशन नंबर सो एंड सो गोड्डा डिस्ट्रिक्ट गोड्डा bearing only serial number 7576 from the present settlement। मिस्टेक लिस्ट मोजा तालुक सो एंड सो जो होता है हुजूर उसका। आबिद हुसैन कौन थे? तो ओरिजिनल डिफेंडेंट के पिताजी। आबिद हुसैन was the father of, was the son of जैनुद्दीन और अलीमन। आबिद हुसैन का बयान है कि हमारा बाप जैनुद्दीन जो है ये दूसरी पत्नी का बेटा है। जैनुद्दीन हुसैन जेहल खाना में है। हमारी माँ का नाम मुस्मा अलीमन, जोजे मिर्जा जैनुद्दीन हुसैन का नाम दर्ज होना चाहिए। ये इनका एप्लीकेशन पर हुआ है। उसके बाद देखा जाए मिर्जा अशरफ हुसैन, ये लोग थे लिविंग सन।
ये हमारी माँ का नाम क्या है?
अलीमन, हमारी माँ का नाम मुसम्मद अलीमन। अलीमन जोजे मिर्जा जैनुद्दीन, जोजे मिर्जा जैनुद्दीन,
जो मतलब
जोजे वाइफ
Your Lordship may compare it with the genealogical, their own genealogy. I am not disputing that
नहीं
Abid was the son of
इसी पर केस है, इसी पर केस है।
आप हमको बस इतना बताइए, इसमें ये कहाँ एडमिशन है कि जो सेकंड वाइफ का क्या नाम है?
फिरोजा खान।
फिरोजा खानम। ये बच्चे फिरोजा खानम से
फिरोजा
लिए
खानम का जो बेटा था ना हुजूर, उसका नाम आया है।
नहीं, फिरोजा खानम का तो
जैनुद्दीन चूंकि जेल में था, दूसरी वाइफ का बेटा जैनुद्दीन होगा, अब वो जेल में था, तो आबिद जैनुद्दीन का बेटा है। आबिद कौन है? तो जैनुद्दीन का बेटा है। तो आबिद हुसैन कह रहा है,
जैनुद्दीन के बेटा समझ आ रहा है, जैनुद्दीन की माँ का क्या नाम है? और उसके बाप
जैनुद्दीन की माँ वही,
भाई उनके बाप पे तो कोई डिस्प्यूट नहीं है।
नहीं,
उनकी माँ के नाम पे
जैनुद्दीन, हाँ, फिरोजा खानम।
कहाँ से?
हम जो जेनोलॉजिकल टेबल फर्निश किए हैं,
ये जो आपने डॉक्यूमेंट
नहीं,
बोल रहे हैं ना कि ये एडमिशन है इनका,
इनका एडमिशन
हाँ, इनका एडमिशन में दिखाइए कि कहाँ बोले हैं कि इनकी जो माँ है, इनका नाम
माँ,
फिरोजा।
चूंकि बेटा आ गया ना, इसलिए माँ का नाम नहीं है।
अरे बेटा के साथ तो माँ बाप दोनों का नाम जुटा है ना।
बाप का नाम
हाँ,
रहेगा,
बाप
माँ
का
का
नाम तो
नाम
रहेगा, लेकिन माँ का नाम कहाँ से आ रहा है?
क्योंकि फिरोजा खानम को एक बेटा हो गया जैनुद्दीन।
नहीं, फिरोजा खानम का नाम इसमें आप कहाँ से पढ़े?
फिरोजा
बाप
खानम
का नाम है, दादा का नाम है, बेटा का नाम है।
सिंपल, जस्ट आई एम ट्राइंग टू एक्सप्लेन। इसमें है कि आबिद हुसैन कौन है?
कौन?
ये मिर्जा जैनुद्दीन का लड़का है। अब मिर्जा जैनुद्दीन कौन है? तो फिरोजा खानम से
एक सेकंड।
बीबी फिरोजा खानम,
देखिए,
she might not have been living on that.
एक सेकंड। इसमें लिखा है कि आबिद हुसैन, यानी कि
इसमें हुई देखा जाएगा मिर्जा विलायत को
आबिद हुसैन,
जी,
ठीक है।
तो आबिद हुसैन जो है,
उसके बाप का नाम जैनुद्दीन है।
बाप का नाम जैनुद्दीन है।
ठीक है।
अच्छा, तो बाप उस दिन चूंकि उसका जेल में था, ये फैमिली सेटलमेंट हो रहा है,
सर,
उसके अनुसार से
कहीं पर भी बाप हो, बाप तो हो ही सकता है ना, जेल में रहे चाहे डेथ हो गया।
हाँ, तो जेल में है,
इसीलिए
तो
इससे
क्या लिख रहा है उसको देखिए ना।
हाँ, ठीक है, पढ़िए। आबिद हुसैन
का बयान है
हाँ
कि हमारा बाप जैनुद्दीन,
हाँ ठीक है,
जैनुद्दीन तो देख लिया,
आगे आगे पढ़िए।
जैनुद्दीन का बेटा हो गया, जैनुद्दीन हो गया बेटा फिरोजा खानम का।
हाँ, आगे पढ़िए।
हाँ, हमारा बाप जैनुद्दीन हुसैन जेहल खाना में है,
हाँ ठीक है,
तो वो सेटलमेंट अथॉरिटी के सामने अपियर नहीं हो सकते थे।
ठीक है।
हमारी माँ का नाम मुसम्मत अलीमन है,
मोहम्मद अलीमन।
अलीमन है, मुंह लिखा हुआ है और अलीमन लिखा हुआ है।
अलीमन कौन?
अलीमन हो गई जैनुद्दीन की माँ, पत्नी।
ओके,
आबिद की माँ हो गई अलीमन।
ठीक है, ओके।
झगड़ा का जहाँ जड़ है हुजूर, उसी का ये निराकरण है। झगड़ा का जड़ ये क्या कर रहे हैं, वो डिस्प्लेस करना चाहते हैं ओरिजिनल जो है।
कहाँ से ये अलीमन का बात आ रहा है?
अलीमन का बात कहाँ से आ रहा है? डॉक्यूमेंट लगा हुआ है, आप देखिए। आपके क्लाइंट से बेसी जानकार इस चीज को कौन समझेगा? He has traveled with dishonest intention to grab the property, entire property.
ये आबिद हुसैन जो है, इनके बाप
वो
का नाम
अलग-
है, सर एक सेकंड, आराम से, शांति से।
जी,
ठीक है। आबिद हुसैन के बाप का नाम है जैनुद्दीन।
जी,
ठीक है। जैनुद्दीन की वाइफ का नाम है
अलीमन।
अच्छा, उसके आगे पढ़िए।
अलीमन,
तो उनकी
इसमें-
जैनुद्दीन की वाइफ का नाम अलीमन है।
जो
इससे ये कैसे प्रूव होता है कि मिर्जा जैनुद्दीन की माँ का क्या नाम?
जैनुद्दीन जो है फिरोजा खानम का बेटा है।
डॉक्यूमेंट से ये कहाँ से प्रूव होता है कि जैनुद्दीन की माँ का नाम फिरोजा खानम?
जैसे देखे एक बात, वो तो एक प्रूफ है ना, विलायतुल खानम का
सर, ये
बेटा
तो
हुआ।
अनडिस्प्यूटेड फैक्ट है। एक सेकंड सर, ये अनडिस्प्यूटेड फैक्ट है कि मिर्जा जैनुद्दीन का
बेटा आबिद है,
आबिद है,
ये
undisputed
अनडिस्प्यूटेड हो गया, बस वहीं से आइए
और
ना,
जैनुद्दीन की वाइफ का नाम अलीमन है, ये भी
ये भी
undisputed
प्रूव हो गया,
अनडिस्प्यूटेड
हो गया।
प्रूफ का
तो
जरूरत ही नहीं
ये ना तो मिर्जा जैनुद्दीन किसका बेटा हुआ था?
तो मिर्जा
मिर्जा
जैनुद्दीन
जैनुद्दीन जो है, मिर्जा जैनुद्दीन बेटा हो गया फिरोजा खानम से,
ये कहाँ लिखा
विलायतन हुसैन से,
ये
विलायतन
कहाँ
हुसैन,
लिखा है कि फिरोजा खानम से वो उनका बेटा हो?
ये जो खाना देखिए ना उसमें,
तीसरा वाइफ का नाम खाता खुला वो से क्लियर हो जाएगा, लेकिन उसकी बात उसका बेटा नहीं है।
तो इसमें तो ये तो हमको प्रूफ केवल ये करना है, ये जो प्रूफ करना
आपको
है
सिर्फ एक ही चीज प्रूफ करना है
जी,
कि ये जो मिर्जा जैनुद्दीन की माँ का नाम फिरोजा खानम,
हाँ
इतना ही प्रूफ करना है। और फिरोजा खानम है और बीवी जो जुमराती खानम नहीं।
देखिए ना जरा सा, इसको इंटरेस्टिंग है, तीसरा कॉलम में आइए ना जरा सा,
तीसरा
27 के सामने में जो आबिद हुसैन का बयान है, ये जो लिखा हुआ है ना, हुसैन खाना में हमारी माँ का नाम अलीमन है, जो जैनुद्दीन हुसैन का नाम दर्ज होना चाहिए। ये देखे उसके बगल में दाहिने तरफ जस्ट क्या लिखा हुआ,
हाँ, ठीक है, पढ़।
मिर्जा जैनुद्दीन का नाम खारिज करके मुसम्मद अलीमन का नाम दर्ज करें।
ठीक।
तो अलीमन जैसे ही हो गई तो अलीमन कौन हुई? आबिद की माँ हो गई, अलीमन आबिद की माँ हुई,
ठीक है, आबिद की माँ
तो हो गई। तो फिर ये आबिद की माँ यदि अलीमन हो गई तो फिर बीबी जुमराती खानम उसकी माँ कैसे होगी?
बीबी जुमराती खाना
उसकी माँ कैसे होगी? उसकी माँ तो अलीमन एक बार हो गई तो फिर जुमराती खानम कहाँ से होगी?
जिससे इस तरह हिस्सा भी मिला।
यही तो झगड़ा है। इसी को डिस्प्लेस करने के लिए जेनोलॉजी का टेबल जो है इस तरह से दे रहे हैं। यही बात सुप्रीम कोर्ट कहता है।
आबिद हुसैन का बयान है कि हमारे बाप जैनुद्दीन हुसैन जेल खाना में है, हमारी माँ
क्या नाम?
शबनम खातून है,
शबनम खातून,
सनाम क्या नाम है इसका?
हमारी माँ का नाम अलीमन,
अलीमन,
योजे मिर्जा जैनुद्दीन हुसैन का नाम दर्ज होना चाहिए।
ठीक है,
ये वहाँ पर
तो
दरखास्त दे रहे
इन्होंने
हैं।
बोला कि जैनुद्दीन की जगह माँ का नाम दर्ज होना चाहिए।
हाँ,
ठीक है,
तो जैनुद्दीन
तो
के
इससे जैनुद्दीन की माँ का नाम कैसे आया?
तो जैनुद्दीन का जस्ट अब यहीं पर क्लियर हो गया कि जैनुद्दीन की माँ का नाम अलीमन, यदि जैनुद्दीन की पत्नी का नाम यदि अलीमन हो गया तो फिर जो है ये जुमराती खानम कहाँ से आ गई? जुमराती खानम से उसको क्या मतलब है?
नहीं,
जुमराती खानम
एक
को
सेकंड सर, आप अपना वो खोलिए, आप प्लेट खोलिए जरा,
हाँ,
अपना जीनोलॉजी खोलिए।
इसमें देखिए ना, मिर्जा जैनुद्दीन का
सर,
नाम
एक सेकंड।
खारिज करके अलीमन का
Just a
नाम
moment,
दर्ज
वो
कर।
खारिज बात नहीं, ये जरा देखिए, जो आपका मिर्जा जैनुद्दीन की वाइफ का नाम आ गया।
अच्छा, उसके बाद और जरा सा उसी को देखिए ना, और क्लियरिफाई करता है ये डॉक्यूमेंट। मिर्जा अशरफ 27 के नीचे 76 जो है ना, बाएं तरफ देखा जाए 76,
हाँ,
मिर्जा अशरफ हुसैन का बयान है। अब अशरफ हुसैन जो है, ये मिर्जा अशरफ हुसैन आ गया हुआ,
कौन है ये अशरफ?
ये अशरफ हुसैन हो गया है इसके ग्रुप में,
इस जीनोलॉजी में
पहली
अशरफ
वाइफ
हुसैन
के
का
ग्रुप
काम
में
नहीं।
पहले वाली।
अशरफ
यूसुफ
हुसैन फर्स्ट
हुसैन।
वाइफ का बेटा,
हाँ,
फर्स्ट वाइफ से है।
फर्स्ट वाइफ से विलायतुल खानम थी, सेकेंड वाइफ हो गई फिरोजा खानम, और थर्ड वाइफ हो गई जुमराती। अब जुमराती का ही जो है ये बीबी फिरोजा खानम जो है, इसी का बेटा हुआ जैनुद्दीन। अब यहाँ पर कोई डिस्प्यूट नहीं है कि जैनुद्दीन उसका बेटा हुआ। तो जब जैनुद्दीन उसका बेटा हुआ तो जैनुद्दीन का बेटा कौन हो गया? आबिद हुसैन हो गया। आबिद हुसैन कौन हुए? जो प्रेजेंट डिफेंडेंट है उसके पिताजी हो गए। तो नेसेसरली वो जुमराती कहाँ से? अब दूसरा नेक्स्ट पेज भी, अच्छा उसके नीचे और जरा सा पढ़ देते हैं, इस मिल में नहीं, उसको इनकम्प्लीट पढ़ देते हैं। हम लोगों के जमाबंदी इलाहादे मुताबिक कब्जा होना चाहिए। कहा है कि हम लोग का सेपरेट
इसका आबिद
आबिद हुसैन बेटा
सर, इस पूरे इसमें
जिसको
फिरोजा खानम का नाम कहाँ है? इस पूरे इसमें फिरोजा खानम का नाम कहाँ है?
हाँ।
या जुमराती खानम का नाम कहाँ?
हाँ, तो फिरोजा खानम,
हाँ,
फिरोजा खानम इसमें एक बात और है। अब दूसरा पेज जो है, दूसरा नहीं तीसरा पेज, ये एनेक्सर 1A जो है,
और दूसरी बात
इसको
ये जो
एक इसी को पहले क्लियर कर रहे हैं, इसी को कहा कि इसी डॉक्यूमेंट पर जो है इनका, क्योंकि ट्रायल
सर,
कोर्ट
लेकिन ट्रायल कोर्ट और एपेलेट कोर्ट
ट्रायल कोर्ट ने इसको डील नहीं किया।
ना तो ट्राई कोर्ट ने डील किया है?
नहीं किया,
क्या?
अपीलेट कोर्ट ने डील किया है।
कहाँ डील किया?
हाँ,
बताइए।
यही तो है।
क्या फाइंडिंग है
अरे,
अपीलेट कोर्ट
रुको।
का कि एग्जिबिट 7 से प्रूव
एक
होता है कि
सेकंड इसको कंप्लीट करके आगे बढ़ते हैं।
इसमें तो नहीं दिख रहा
हाँ,
है।
यहाँ देखिए ना, अब ये जुमराती खनम जो है, देखिए इन लोगों का जब नाम आ रहा है, फिर नेक्स्ट पेज में आ गया, जो 15 पेज पर एनेक्सस 7A1 मिर्जा अशरफ हुसैन रैयत खाना हाजा का बयान है कि चंद रमजान हमलों के बख्श खाना पूरी इजमाल दर्ज हुआ है, हम लोग तसफिया करके बांट लिया है। तफसील जेल के खास खाता में दर्ज होना चाहिए, जिसके मिर्जा आबिद हुसैन बेटा अलीन शरीरदार ने कबूल किया।
ठीक है, आबिद हुसैन की माँ के नाम पे तो कोई डिस्प्यूट नहीं।
हाँ,
सारा डिस्प्यूट है।
अब जस्ट
मिर्जा जरीफ
जस्ट नीचे आइए,
जैनुद्दीन हुसैन।
जस्ट नीचे आइए। अब देख लीजिए, यहाँ पर जुमराती खनम के यदि उसको बेटा था तो फिर इसका नाम अकेले का आएगा। जुमराती खनम का नाम यहाँ पर आ रहा है रिकॉर्डेड टेनेंट पे, यही प्रॉपर्टी रिकॉर्ड हो रहा है 4 बीघा कुछ कट्ठा। यही जुमराती खनम अलग रिकॉर्डेड टेनेंट यहाँ पर आ रही हैं। यदि इसको बेटा था तो बेटा का नाम होना चाहिए था।
सर, उस समय जुमराती खानम का डेथ हो चुका था।
नहीं, उस समय जिंदा थी।
जिंदा थी तो उसके नाम से तो उसी का रहेगा ना, बेटा का नाम
नहीं तो
कैसे
अलग
होगा?
बेटा जो है तब तो आबिद जो है, आबिद कैसे चला गया वहाँ? आबिद वहाँ कैसे आ
एक
गया?
बात बताइए, मुस्लिम
आबिद
लॉ
के-
में जिसके नाम से प्रॉपर्टी है उसी के नाम से
आबिद
रिकॉर्डेड
तो
रहेगा ना।
आबिद जो है जैनुद्दीन का बेटा आपने को कह रहा है, तो जैनुद्दीन की पत्नी का नाम अलीमन है। अलीमन उसकी माँ हुई। तो जब
नहीं, आप हमको जरीउद्दीन की
अब
वाइफ का नाम अलीमन है,
जरा सा
तो अलीमन जरीउद्दीन की माँ कैसे हो जाएगी? ये जरा हमको
अब
समझ।
देखिए ना, जैसा हम उसको क्लियर है इसी डॉक्यूमेंट से।
ठीक है, हम वही डॉक्यूमेंट ही देख रहे हैं।
नहीं
आप हमको इस डॉक्यूमेंट से
जैसा मेरे तरफ से देख लिया जाए, इसको देखिए कैसे क्या है।
आप ही की तरफ से देख।
हाँ, देखिए जुमराती खनम, अब इसमें सबका नाम रिकॉर्ड हो रहा है। किसका किसका नाम हो रहा है?
हाँ।
जुमराती का नाम हो रहा है, अलीमन का नाम रिकॉर्ड हो रहा है। तो जुमराती भी आई तो अलीमन कहाँ से आ गई? यहाँ पर कहीं भी केस डिनाई कर
अलीमन इसलिए आ गई क्योंकि उनके हस्बैंड जेल में।
जैनुद्दीन थे।
बेटा आके
तो
बोला
इसका
कि भाई मेरे पापा जेल में हैं, तो मेरी माँ का नाम दर्ज।
माँ का नाम हो गया,
हो गया ना।
माँ का नाम हुआ ना, तो किसी के कहने पर तो जेल। इसका कैसे नाम आया?
किसका?
जुमराती खनम का
जुमराती खानम का नाम इसलिए आया सर क्योंकि she was the owner of the property.
owner
They
and
wanted
soul.
owner
She
of
was
the
not being succeeded by anyone.
अभी सक्सेशन तो तब ना होगा जब वो मरेंगी।
तो
Unless she
आखिर
dies,
जिंदा बेटा
unless she
रहेगा तो
dies-
बेटा का नाम नहीं आएगा।
Sorry?
बेटा यदि एडल्ट है तो उसका भी तो
नहीं,
नाम
कैसे आएगा? ऑटोमेटिक कैसे आएगा? ऑटोमेटिक नाम आ जाएगा उसका, नहीं आएगा।
नाम जो दरखास्त दे रहा है,
नहीं, कोई नहीं, किसी के दरखास्त देने से किसी का नाम नहीं आ जाता। जिसके नाम से प्रॉपर्टी है वो उसी के नाम से रहता है।
यहाँ तो नाम में तो डिस्प्यूट नहीं है।
नाम में तो dispute
यहाँ तो
नहीं
नाम में डिस्प्यूट नहीं है।
कोई बात नहीं।
और डॉक्यूमेंट्री एविडेंस जो आपको हम दिखा रहे हैं 7 and 7A, इसका कंसिडरेशन एप्लीकेट किया।
लेकिन
कैसे किया है?
इस डॉक्यूमेंट को ऑन द फेस ऑफ इट हमको कहीं नहीं मिल रहा है कि जहीरुद्दीन की माँ का नाम
नहीं
फिरोजा खानम।
जैनुद्दीन वहाँ कोई नहीं है।
ऐसा कहीं नहीं है कि जहीरुद्दीन की माँ का नाम फिरोजा खानम।
नहीं, यहाँ तो जैनुद्दीन है। 3 पत्नी है ना हुजूर, 3 पत्नी है। पहली हुई विलायत खानम, जिसके ब्रांच में हम हैं। विलायत खानम के ब्रांच में हम।
अनडिस्प्यूटेड।
उनका बेटा हुआ मिर्जा यूसुफ हुसैन,
अनडिस्प्यूटेड।
हो गया। दूसरा हो गया यहीं से झगड़ा का कर जो है मेन, जो इसके क्राफ्टमैन ऑफ द इंटायर मैंने फ्रॉड बीइंग कमिटेड ऑन द फैमिली।
फ्रॉड का कोई एलिगेशन नहीं है सर।
हाँ, एविडेंस है ये तो अपरेंट ऑन द
फ्रॉड
फेस
का
ऑफ
कोई
सेक्स।
एलिगेशन तो हमको नहीं दिखा।
हाँ,
डेट एंड डेट।
अब जस्ट सेकंड वाइफ में बीबी फिरोजा खानम है, ठीक है। उसका बेटा हो गया जैनुद्दीन, जैनुद्दीन का बेटा हो गया आबिद, आबिद का बेटा हो गया अभी जो डिफेंडेंट्स हैं।
सर एक ही चीज को बार-बार बोलने से
और
तो सही नहीं होता।
आबिद है एक्सेप्टेड कि अलीमन उसकी माँ है।
अलीमन माँ होने से क्या हुआ?
ये
अपनी दादी को
तो
accept
आबिद की
किया।
माँ फिर अलीमन यदि हो गया अलीमन, तो फिर आबिद कैसे कहता है कि हम जुमराती का बेटा है? सिंपल, अभी यदि एक्सेप्ट बस शी हैज एक्सेप्टेड कि ये हमारी माँ अलीमन है, तो फिर जुमराती का बेटा कैसे होगा?
नहीं अलीमन
अलीमन को एक्सेप्ट कर रहा है ना,
एक सेकंड
एक्सेप्ट कर रहा है
सर,
सेवन।
आप ही का उसमें आ रहे हैं।
जी जी
ठीक है, आपकी जरूरतीन है, ठीक है,
जयवती
उसकी वाइफ है बीबी अलीमन,
अलीमन
हाँ, और उसका बेटा है
अभी, exactly।
एक सेकंड, थोड़ी शांति रखिए सर, थोड़ा सा
नहीं,
हम बिना समझे तो जजमेंट नहीं कर पाएंगे ना,
ऐसा
इसलिए
हो सकता
समझना
है,
जरूरी है।
ऐसा हो सकता
आपका जो ये जिनोलॉजी है
जी
इसमें आ गया है एग्जिबिट 7 से ये आबिद हुसैन की माँ का नाम अलीमन है, ठीक है, उसके बाप का नाम जरीउद्दीन
Exactly।
आ गया, देयर इज नो डिस्प्यूट।
हो गया, हो गया।
लेकिन ये कहाँ आ रहा है कि जरीउद्दीन के माँ का नाम फिरोजा खान,
ये भी तो नहीं आ रहा है कि जन्मदिन का माँ का नाम फिरोजा जुमराती खान।
ये नहीं आ रहा है ना,
ये
तो
नहीं।
इसके बेसिस पे एप्लेट कोर्ट जजमेंट कैसे कर देगा कि
appellate court में तो
जरीउद्दीन
उसको
की माँ का नाम फिरोजा खान है?
appellate
आप बोले
court-
कि इस पे रिलाई करके एप्लेट कोर्ट जजमेंट,
हाँ, इस पर ही नहीं किया है और डॉक्यूमेंट को,
और
क्या कि
कौन सा?
सारे डॉक्यूमेंट को उन्होंने डील किया है।
और
अब
कौन सा?
इनका
इसको-
परवर्सिटी का
नहीं इसको जो डील किए हैं वो कहाँ है, दिखाइए कैसे डील किया एप्लेट कोर्ट, लेट अस सी, वी हैव सीन द डॉक्यूमेंट,
जी 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 जी
विल सी हाउ द एप्लेट कोर्ट हैज डेल्ट विद इट।
पूरा देख ला हुजूर के पेशेंट हियरिंग और पूरा ही पर को हमको हुजूर इतना भरोसा है कि जिसका ठिकाना नहीं। लॉर्डशिप इज गिविंग टेकिंग 2 months पेज। इशू तो मेरे मित्र ने हुजूर को दिखला दिया। अब काइंडली कम टू जो चीज आप देखना चाहें। जो पेज नंबर 22 हुजूर, हम यहाँ से हुजूर के यहाँ से ही हम सब
पेज नंबर 22
पेज नंबर 22 पर है।
पैरा नंबर 18 पर एप्लेट कोर्ट का पैरा नंबर 18, इट इज एडमिटेड दैट,
देखना पड़ेगा पैराग्राफ 18 का।
ये पेज नंबर 21 में बॉटम में है सर,
पेज नंबर
21 एप्लेट कोर्ट जजमेंट का बॉटम में, इट इज एडमिटेड दैट,
It is admitted that the suit property is recorded in the name of Jubrati Khan. Right, paragraph 11 of the written statement. Exhibit 6 is the parcha of Jawamandi number 26 of Asan Bani, recorded in the name of Jubrati Khan. The learned counsel drew my attention to the boundary of plot number 35 and 47. From perusal of the same, it appears that in northern boundary of those plots, name of Mirza Jainuddin appears. This leads to the inference that Jainuddin was the son of Jumrati. That if Jainuddin was the, अब इसी पॉइंट को डील कर रहा है, if Jainuddin was the son of Jumrati, then in the boundary name of Jainuddin should not have been mentioned.
जस्ट अ मोमेंट, इसको फिर से पढ़िए सर।
जी
नॉर्दर्न पोर्शन में मोहम्मद मिर्जा जहीरुद्दीन का नाम है, ठीक है,
जैनुद्दीन का
this leads to the inference
जी
that if Jalaluddin was the son of Jumrati,
जी
then in the boundary name of Jalaluddin
जी
should not have been
should
mentioned. इसका क्या मतलब?
जैनुद्दीन तो दूसरा ब्रांच में हो गया, जो जुमराती जो हुई वो रिकॉर्डेड नहीं था इस केस में।
बाउंड्री में नाम है ना सर, बाउंड्री में तो हो ही सकता है ना, किसी का नाम पड़ोसी का नहीं हो सकता।
अलग अलग नाम से मतलब है, यहाँ जैनुद्दीन और जुमराती। जैनुद्दीन हो गया बेटा जिसके बारे में हुजूर कह रही हैं कि ये कैसे बेटा, इसकी फिरोजा खानम का बेटा, हम लोग कह रहे हैं फिरोजा खानम का बेटा है जैनुद्दीन। तो फिरोजा खानम का बेटा जब जैनुद्दीन है, सेपरेट आदमी है, उसका नाम सेपरेट आ रहा है। फिरोजा खानम यदि उसका बेटा था,
माँ और बेटा का नाम एडजॉइनिंग नहीं हो सकता है, ये कैसे?
तो हुजूर कहाँ पर, उनको अलीमन जो है, अलीमन मतलब अपनी माँ का बतला रहा है। अलीमन जब उसका माँ हो गया तो फिर जुमराती उसकी माँ कैसे होगी? यही तो खेल है इंटायर जो है इसमें, क्रक्स ऑफ द मैटर इतना है।
कहने में जरूरी उसकी माँ नहीं,
हाँ।
जमुनी उनकी माँ नहीं है।
जैनुद्दीन की माँ यदि रहती तो फिरोजा का नाम नहीं रहता,
तीसरी का नाम नहीं, तीसरी का नाम
जुमराती खानम का नाम नहीं रहता। जुमराती का चूंकि वो बेटा नहीं है इसलिए जैनुद्दीन का नाम
नहीं, बाउंड्री में किसी का नाम है, इसका मतलब इससे आप रिलेशनशिप कैसे
ये
डिराइव कर सकते
सेकेंड अपील में योर लॉर्डशिप इज टेकिंग टू मच पेन टू डील ऑल दीज मैटर्स, लेकिन सेकेंड
नहीं,
अपील में
क्योंकि-
सिर्फ ये देखना है कि वेयर इज द परवर्सिटी
हाँ,
कमिटेड
वही
बाय
आप
द कोर्ट
perversity
बिलो।
पर ही नजर है।
परवर्सिटी जो है कहाँ क्या
सर,
अब यहाँ
मेरी
पर,
परवर्सिटी पर ही नजर
हाँ तो यहाँ पर कहीं नहीं आ रहा है, ये उनके केस के अलावा ये कहीं से नहीं आ रहा है कि जैनुद्दीन जो है वो जुमराती का बेटा है, ये कहीं से नहीं है सिवा उनके केस के। उनका जो केस है कि हम जुमराती का बेटा है, इनफैक्ट जुमराती है डैट इशूलेस।
आगे बढ़िए। एग्जिबिट 7 इज
एक सेकंड पहले ये तो मैडम पढ़ रही है इसको,
Exhibit 7 is a
पढ़िएगा इसको, जैसे पढ़िएगा जब पढ़िए दिस लीड्स टू द, यहाँ पर इन्फ्लुएंस, फिर से एक बार
This leads to inference that Jainuddin was the son
that
of
thing.
Jumrati.
This leads to inference that
If
if Jainuddin,
Jainuddin was the son of Jumrati, then the bounding name of Jainuddin should not have been mentioned. Exhibit 7 is a mistake list that is sub-16 25 from perusal of that serial number 75. It appears that Abid Hussain had made as a statement that his father is in jail, so his mother, Most Aliman, wife of Mirza Jainuddin, was be recorded. At serial number 76, the statement of Ashraf Hussain of that separate Jamabandi according to position may be recorded. It further appears that Ashraf Hussain and Mirza Yusuf Hussain, the heirs of the first wife, Most Aliman, wife of Jainuddin and mother of Abid Hussain, and Jumrati Khabun had signed on it, मतलब 3 branches with signed की. It suggests that in 1925, properties were recorded in different Jamabandi and Abid prayed that name of his mother may be recorded in place of his father. And according his mother's name appears, if Jainuddin was son of Jumrati, then name of Jumrati would have been mentioned separately. Exhibit 7/1 is another mistake list from perusal at also the same fact is apparent. 3 bunches had been recorded separately with respect to specific share. If Jainuddin was the son of Jumrati, the name of mother of Abid not have been there. Aliman का नाम तब नहीं होता. It appears that learned court below has discarded exhibit 9 and 10, saying that there is no finding in judgment that Violet had 3 wives. He has not considered the statement of admissions of the respondents made in exhibit 9 and 10 in the light of section 17 and 18 of Evidence Act. Likewise, exhibit 7 series have been discarded on the ground that there is no mention that Violet had 3 wives. It is a revenue record and it shows the division of the property in 3 branches. No doubt, those exhibits 7 and 7/1 are not conclusive but certainly support the appellant's case as discussed above. For disbelieving exhibit 9 and 10, the learned court below has given another ground by para 13 of the impugned judgment that plaintiff has to prove his case and he can't act. He cannot take advantage of weaknesses of the witness. In this case, no case of weaknesses of defendant arises. It is the admission made by the defendant in another litigation between the same party, and still it is pending according to them before the Honorable High Court. In para 14 of the trial court has stated that PW1 and PW9 have been cross-examined on the point of wife and son, which appears to be an error of record. I have discussed above and found contrary. Exhibits 8 series are the rent receipts filed by the plaintiffs which support their position, which have not been taken into accordingly. The learned trial court, the position पर admit कर रहे हैं, which have not been taken into according. The learned trial court evidence of DW6 and DW7 have not been considered in the light of section 15 32(5) of Evidence Act. The learned counsel of the respondent submitted that Amjadi Begum, maternal grandfather, mother of plaintiff, had filed RM case number 209 Exhibit D, where she has admitted that Waliad Hussain had two wives, Zumrati and Waliad. It appears that a genealogy table has been given showing two wives and Zumrati have been shown as the first wife, which is not a case of either party. Moreover, the plaintiff is not claiming through Amjadi Begum as such. Her statement is not binding upon plaintiff. In the said Exhibit D, there is nothing to show that Januddin was the son of Jamrati Khanam. So, on the basis of Exhibit D, it cannot be concluded that Januddin was the son of the most Jumrati Khanam. The learned court below stated that because Amjadi is a name of plaintiff, it cannot be overlooked without considering as to how it can be used against the plaintiff. I find that in Exhibit D, Amjadi has not admitted that Januddin is the son of Jumrati Khatun. So it is not helpful to the respondents. Exhibit A series are the rent receipts. Considering the oral evidences, documentary evidences, and facts of the case discussed above, I came to position of whether there is no specifically no adverse position. Accordingly, I find the plaintiff has got immunity of right, title, and position over the suit plans. The finding of the trial court on this point is reverse. I further hold that plaintiff is entitled to relief claimed by her in the result and judgment degree of the trial court are set aside, and this appeal is allowed. The plaintiff claims suit for partition to the extent of her 4 hours and 4 hours. Defendant number 2 is agreed to cost.
Therefore, what I want to submit note simple.
सर आपका अभी बारी नहीं आया, आपसे खाली पूछ लिए थे इस पर, because Exhibit 7 में इनको कंप्लीट करने दीजिए, उसके बाद आप लेट हिम कंप्लीट हिज राइट. ऐसे बीच में क्या होता है, कंफ्यूजन हो जाएगा. लेट हिम कंप्लीट हिज आर्गुमेंट.
Certainly, prosecuting court के द्वारा
उसको कंप्लीट करने दीजिए, आर्गुमेंट कंप्लीट.
So therefore, Your Lordship, from perusal of the appellate court judgment, Your Lordship would find that the trial court had given a very specific finding that Vilayat Hussain had only 2 wives and there was no third wife, namely Firoza Khanum, which has been reversed by the appellate court on a ground which was not even there. So therefore, my
I'm not
contention
able to figure out what is the ground for reversing. Because Exhibit 7
therefore, Your Lordship, it has to be Exhibit 7 and it says one more exhibit which is there in my own admission in so-called title suit number 285, the judgment, where I have admitted that he had 3 wives. And he relies on the judgment despite the fact that the plaint of the same title suit was already there on it.
in the plane there is no.
No. I will read out the plaint, Your Lordship, that is marked as exhibit. It is marked as exhibit.
The court has drawn an inference that merely because his name of his wife was introduced, therefore his mother was.
Absolutely absurd. Now here the question is, who was the mother of Jainuddin, not who was the mother of Abid. So what was the name of mother of Halima? Therefore the Jainuddin's mother was Firoza. How this is established, I would fail to understand. And therefore all these Exhibit 7 and Exhibit 9 and 10. 9 and 10 is the judgment of past in title suit number 285. All these have been wrongly considered by the court to come to a conclusion that there were 3 wives and P.B. Jumrati died issues.
And even if the court comes to a conclusion that there were 3 wives, that by itself does not decide as to who was the mother of them.
Yes, that does not decide.
Even if this finding
Absolutely. It has to.
2 wives or 3 wives or 5 wives will not decide the mother.
Only to show that their contention, the whole story which was pleaded by them was that there were 3 wives and the 3rd wife was Jumrati and she had died issueless. So therefore, my contention would be this: at least in second appeal, this question falls for consideration. What would be the ultimate outcome, judgment of your lordship? That would be answered subsequently. But this falls for consideration as to whether the appellate court has rightly the reversal of the decree dismissal passed by the trial court was by the appellate court was reversal. So one more exhibit, if your lordship would see, that was RM case number. It was their own petition by their own predecessor in interest, where she files a genealogy and she says that Vilayat Husud Haswan had only two wives, Jamurti and Vilayat.
Who filed this? Who filed this case?
This was filed by Amjadi, which your lordship would find from the genealogical table. Amjadi was own grandmother of the plaintiff, Bibi Amjadi. Your lordship would get her name in the genealogical table. This genealogy shows that Vilayat Hussain had only Jamurti Khanum as wife number 1, Vilayat Khanum as wife number 2, and then other genealogical table has been mentioned.
This is exhibit number.
This is exhibit number D.
Where is the discussion of exhibit D in the appellate case?
Yes. Yes, it is there just before in para 20. Para 20. The learned counsel for the respondent submitted that Amjadi Begum, maternal grandmother of plaintiff, had filed RM case number so para 20. नहीं यहाँ पर नहीं.
फाइंडिंग रिकॉर्ड होने के बाद लिखते हैं ना. ये तो फाइंडिंग पे नहीं लिखी है.
इसी में आगे में कंसिडरेशन है इसके बारे में, इसी पैरा 20 The learned counsel for so and so submitted that Amjadi Begum so and so, grandmother of plaintiff, had filed RM case number so and so. Exhibit D, wherein she has admitted that Vilayat Hussain had two wives, Jugrati and Vilayatul. It appears that a genealogical table has been given showing two wives, and Jugrati has been shown as the first wife, which is not the case of either party. Moreover, the plaintiff is not claiming through Amjadi Begum. Plaintiff means your lordship, Sabra Khatun. Plaintiff is not claiming through Amjadi Begum. As such, her statement is not binding upon her. Absolutely absurd finding, because she was the descendant of Amjadi. In the said exhibit D, there is nothing to show that Jainuddin was son of Jumrati Khanum. So, on the basis of exhibit D, it cannot be concluded that Jainuddin was the son of Muhammad Jumrati Khanum. The learned court below stated that Amjadi is the name of plaintiff. It cannot be overlooked without considering as to how it can be used as against the plaintiff. I find that Exhibit D, Amjadi has not admitted that Jainuddin is the son of Jumrati Khanum, so it would not be helpful to the respondent. Exhibit students.
जवाब दे दिया हुजूर का जो क्वेश्चन पूछा जा रहा है इसके बारे में फाइंडिंग आ रहा है
क्योंकि नाम से इतना कंफ्यूजिंग होता है
थोड़ा सा नाम हम लोग को तो बहुत करते करते भी अभी कंफ्यूज कर देते हैं
वो इसी के लिए वो genealogical table you have to keep and then only. So my contention is that to Exhibit D would be.
In Exhibit D,
Yes.
there is no mention that there was a third wife. Once there is no mention that there was a third wife. And it is not in dispute that parties are descendant of Mirza Waliyat Hussain.
Yes,
In that exhibit, there is no mention of third wife. So, if it has not been mentioned that that they are the son of Jumrati Khanum, then under such circumstances, the only inference could be that they are the descendant of first wife, which is
yes.
not the case of the
Not the
plaintiff.
case of. So who?
The case of the plaintiff is specifically that
There were
the
three wives.
defendants are the descendant of another wife,
Another.
not
Yes.
first, second, third, fourth.
Yes, yes, yes.
Their case is that defendant was the descendant of third wife.
Second, other
Some
wife.
other
Other
wife, right? Exhibit D says that there were two wives.
Yes.
Although by virtue of Exhibit D, it cannot be said that the mother was Jumrati
No,
Khanum,
no, it cannot.
right? But certainly, it is absolutely out of picture that the defendants was wife of the first wife, the descendants
This
of
is
the first.
first one. Because it is not case of neither of the party. So only inference, and we are the descendants of Vilayat Hussain.
It
This
not
is
in
also
dispute.
not in dispute. So it has to be the only inference that can be drawn is that the defendants were the descendants from the second wife. And the entire case of the plaintiff is that the plaintiff.
You see the relevant exhibits. Oral evidence तो बहुत ज़्यादा relevant नहीं है कि oral evidence भी relevant. Oral evidence में ज़्यादा relevant.
इसी में
Primarily documentary पर ही.
इसी में जो है
Exhibit
तो यही
Exhibit
अपने
7.
फोटो कर रहा है
Exhibit D, Exhibit 7,
7,
and Exhibit 9, 10,
9 is the plaint,
plaint and judgment.
10
No,
is the judgment.
9 and 10 is the judgment and decree.
9 and 10 is the judgment and decree. Plaint conduct.
3
8.
and 4. Plaint.
Plaint is
3 plaint.
plaint is 3.
हाँ
Plaint तो आप produce किए होंगे ना?
नहीं नहीं luckily they are luckily they
Plaint
are
का बताइए plaint कौन सा?
exhibit 3
एग्जिबिट 6 से ही देखा जाएगा
3 exhibit 3
Exhibit 3 is the plaint.
लेकिन फर्स्ट एपलेट कोर्ट यूनिवर्सिटी हैज टेकन पेन टू सी that the first appellate court has dealt with every aspect of the matter
So
and it has formed
exhibit
one opinion.
Exhibit D से जो derive कर रहा है ना inference,
एग्जिबिट
that is absolutely incorrect.
एग्जिबिट डी के बारे में ही कंफ्यूजन आ रहा है
गलत conclusion है ना?
नहीं नहीं वो कह रहा है कि इससे ये प्रूव नहीं होता है कि जुमराती का बेटा जो है
आप
जैनुद्दीन
ये
है
बताइए, अब हमको इतना बताइए, एग्जिबिट डी में लिखा हुआ है कि 2 वाइफ, एक वाइफ का नाम दिया हुआ है बीबी बलिया का,
एग्जिबिट डी मेरा नहीं है वो जिसका है उसमें उसके केस में न तो हम पार्टी थे न कुछ थे, इसलिए उसमें जो भी डिसीजन हुआ रहे उसमें
एग्जिबिट डी कौन फाइल किया है?
आई वाज नॉट ए पार्टी।
एग्जिबिट डी किसका?
डिफेंडेंट
Exhibit D is
डिफेंडेंट्स के
हाँ
डिफेंडेंट
हम लोग फाइल किए थे
एग्जीबिट
किसका
उनका है।
ये अमजदी which was
आमजादी वो हमसे हमारे ब्रांच की ये हो सकती है, लेकिन वो इस केस में जो है हमारा पार्टी
इनकी ग्रैंडमदर है,
आपकी ग्रैंडमदर है?
इनकी
ग्रैंडमदर नहीं थी,
प्लेंटिफ की,
ग्रैंडमदर नहीं थी
वो उसी
आपकी
जेनरल
जियोलॉजी में ही ग्रैंडमदर है।
उसका। अमजादी जो है,
बीपी
अमजादी बेगम जो है, ये टाइटल शूट हुआ था 1/4/47 जो उस केस में आएगा वो चर्चा अलग केस। लेकिन यहाँ जो है इसी के बारे में फाइंडिंग दे हैं। आई फाइंड ये पेज 26 में लास्ट पर 6 लाइन्स में सेंटेंस शुरू होता है। आई फाइंड दैट इन एग्जिबिट डी अमजादी हैज नॉट एडमिटेड दैट जैनुद्दीन इज द सन ऑफ जुमराती खाना। इनका फाइंडिंग है on examination is producing a documentary evidence। वो एक ओपिनियन फॉर्म कर रहा है, it being the last court of fact and law।
सर इसको तो डिसाइड करना ही पड़ेगा ना, क्योंकि ये सारे एग्जिबिट्स को तो बिना देखे
बहुत सारा है। और हुजूर हम डिसीजन जो है
हम सिर्फ इतना ही एक फ्रेम करते हैं कि whether the learned first appellate court has committed
परवर्सिटी एग्जैक्टली
in reversing the finding of the learned
एग्जैक्टली
बस इतना ही खाली करेंगे।
ये देखना है।
बाकी सब
और हुजूर को देखना है कि फर्स्ट ये कोर्ट का ये आता है कि लोअर एपलेट कोर्ट ने ये फाइंडिंग जगह एरर ऑफ रिकॉर्ड है। ट्रायल कोर्ट ने जो कहा, मेरे मित्र ने पढ़ा कि वो एरर ऑफ रिकॉर्ड है। ये सब चीज जो है इट हैज गॉन इन डिटेल मोर देन द ट्रायल कोर्ट। कि ट्रायल कोर्ट ने
जब तक हम लोग सब्सटेंशियल क्वेश्चन नहीं फ्रेम करेंगे ना, तब तक हम इसको कैसे एग्जामिन करेंगे?
सब्सटेंशियल क्वेश्चन तो परवर्सिटी पर है ही नहीं इनका। ही हैज नॉट प्रपोज्ड इट।
नहीं, वो तो हम रिजेक्ट कर दिया उनका by saying that if during the course of argument if we find that
वो तो हुजूर ड्यूरिंग द कोर्स ऑफ, यहाँ परवर्सिटी का जो पॉइंट है तो नो तो प्रपोज किए जो प्लेंट है।
नहीं, प्रपोजल का तो बात नहीं है।
सेकंड
during the course of argument
आज भी जो है परवर्सिटी पर। अब कोर्ट जो है परवर्सिटी कहाँ है कि वह पीस ऑफ एविडेंस, जैसे हम एग्जिबिट 7 और 7A हुजूर के नजर में ला रहे हैं, हमारा उसमें पर्पस है कि उसी के डॉक्यूमेंट से वो कंसीड किया है और माना है वो पार्टीशन है। इनफैक्ट जो है कहा कि यूनिवर्सिटी में देवे कि संथाल पर सेटलमेंट रेगुलेशन में उसको कोर्ट का भी पावर है। वो पार्टीशन जो कर देगा दैट इज बाइंडिंग अपॉन द पार्टी। वो रिकॉर्ड्स ऑफ राइट्स में मेंटेन है। तो उसके आधार पर आ रहा है वो कि जैनुद्दीन का बेटा, जैनुद्दीन की पत्नी अलीमन थी, अलीमन का बेटा आबिद था जो कि उस केस में भी प्लेंटिफ है। यहाँ पर जो है वही लोग डिपेंडेंट है। तो अलीमन का बेटा जब आबिद हो गया तो हुजूर उसमें फिर वो वही आबिद कह रहा है कि हम उसका बेटा है, जुमराती खान का बेटा है।
नहीं ये तो
यही तो आपका
Absolutely
केस है। अरे यही आपका केस है। ये तो क्या बोल रहे हैं, ये तो फाइंडिंग है आपका। यही केस है आपका स्पेसिफिक कि जुमराती का बेटा है हम।
जुमराती का बेटा तो ये है ना,
तो जुमराती का कैसे
जैनुद्दीन
का बेटा नहीं हुआ। जुमराती का बेटा जो है आबिद नहीं है।
आबिद तो
अरे
है ही
हम
नहीं।
क्लेम भी नहीं कर रहे हैं।
वही तो आपका क्लेम है। आबिद का ये जो है इसमें झगड़ा क्या है?
इनका क्लेम है कि ये आबिद इज सन ऑफ जुमराती।
आबिद जो है ये जुमराती का बेटा वो इस्टेब्लिश करना चाहे।
नहीं
this is not the case.
यही तो है। यही तो इसका केस है।
WS देखिए सर, that is not their case. That is not their case at all.
यही केस है।
The statement में दिखाई है ना, WS में दिखाई।
WS में देखिए।
नहीं, आप इनका जिनोलॉजी भी देख लीजिए
हाँ,
ना।
जेनोलॉजी के ही देख लीजिए।
जिनोलॉजी भी
देख लीजिए जुमराती का
जुमराती
बेटा
का बेटा जैनुद्दीन है, आबिद नहीं है।
नहीं, आबिद उसका बेटा हो गया।
आबिद किसका बेटा हो गया?
जैनुद्दीन का बेटा हो गया।
वो तो है ही, वो तो अनडिस्प्यूटेड
हाँ, तो वो तो जुमराती का बेटा यदि
सर क्या एविडेंस है कि जैनुद्दीन जो है जुमराती का बेटा है? We are only concerned with this. जैनुद्दीन का बेटा तो आबिद है, इट इज एन अनडिस्प्यूटेड।
जस्ट a minute। इस केस में हम लोग का जो केस है उसमें हम लोग जो अभी चुना है कि इसमें जो है सो जुमराती जुमराती खानम अलग रिकॉर्डेड इवेंट में उनका जो प्रॉपर्टी छूट गया, जिसको वो एब्सोल्यूट उसको इंजॉय करना चाहता था अभी से, उसमें हमारा भी हिस्सा चला, क्योंकि वो इशूलेस मरी है, उसका कोई डिसेंडेंट नहीं है। तो जो चीज यदि जुमराती मुर्गी
सर एक पे जो कोई मैटर हम रखे हैं, आपसे बस इतना ही चीज हम जानना चाहते हैं, आप हमको जो जो डॉक्यूमेंट के बेसिस पे आप बोल रहे हैं that it goes to prove that Jainuddin was the son of Jumrati, आप वो डॉक्यूमेंट हमको
नहीं, जुमराती का बेटा जुमराती डैड इशूलेस
नहीं, जो
वो
डॉक्यूमेंट एक सेकेंड, जो डॉक्यूमेंट आप बोल रहे हैं कि जैनुद्दीन was son of फिरोजा खानम,
उनको भी तब एक कष्ट क्या हम
टाइम देंगे आपको
लेंगे
जरूर, क्योंकि
हम सारा सब डॉक्यूमेंट से
सारा डॉक्यूमेंट आप देख सकते हैं, आपको कोई प्रॉब्लम नहीं,
उसे हम दिखलाएंगे,
क्योंकि 7 and 7/1 से तो प्रूव नहीं हो रहा है।
नहीं, उससे प्रूफ तो इतना हो जाता है कि आबिद जो एसर्ट कर रहा था, इसको बिल्कुल हुजूर रखा जाएगा कि आबिद जो क्लेम कर रहा था कि हम जैनुद्दीन का बेटा है और जैनुद्दीन जो है सो जुमराती का बेटा है, वो चीज प्रूव नहीं होता है। उसमें होता है कि नहीं, जैनुद्दीन जो है उसका जो है बेटा तो ये हुआ, लेकिन उसकी जैनुद्दीन की पत्नी का नाम नहीं था, क्योंकि जैनुद्दीन उस दिन जेल में था, इसलिए
ठीक है,
उसका नाम आया,
से लेना
और
देना नहीं है ना।
सेपरेटली जुमराती का भी नाम आया।
सर हमें एक जुमराती का नाम तो इसीलिए आ रहा है क्योंकि जुमराती के नाम से प्रॉपर्टी है,
नहीं इसलिए है क्योंकि उसको देखिए
जिसके नाम से प्रॉपर्टी
एग्जैक्टली उसी प्रॉपर्टी का तो झगड़ा है, वो एब्सोल्यूट उसको लेना चाहते हैं, हमको उसे थ्रो आउट करना चाहते हैं, इसलिए जो है सो ये एक गलत जनलॉजी दे रहे हैं।
सर आपका जो डॉक्यूमेंट्स है टू प्रूव दिस फैक्ट, क्योंकि ओरल एविडेंस से तो लेना देना नहीं है,
नहीं ओरल से नहीं है,
तो
डॉक्यूमेंट्री केस पर ही
कौन से डॉक्यूमेंट पे आप रिलाई करना चाहते हैं?
हमारा जो है वो जो इसमें लिखा हुआ है
आप बताइए,
सर रेफर है
एग्जिबिट नंबर बताइए ना,
अपीलेट कोर्ट के जज में
एग्जिबिट नंबर बता दीजिए, एग्जिबिट
सारा अपीलेट कोर्ट ने डील
बताइए कौन से एग्जिबिट नंबर है,
अपीलेट कोर्ट ने जितना डील किया हुजूर सब हम उस पर
एग्जिबिट नंबर बताइए ना सर, थोड़ा सा एग्जिबिट नंबर
क्रमशः जिसको कोर्ट का ये कह रहे हैं
एग्जिबिट नंबर बताइए,
जो 1 से होगा वो
बताइए कौन सा रेलेवेंट एग्जिबिट
सारा है,
according to you
10 तक है, एग्जिबिट 10 तक है, 1 से लेकर 10 तक हम हुजूर सारा रिलाई करेंगे और हम क्या सब कुछ देखेंगे।
एग्जिबिट 1 to 10
I will only take your lordship's leave to examine those, हम जैसे कोर्ट में देखेंगे आगे हम प्लेस करेंगे,
कोई बात नहीं,
क्योंकि ये सारा खेल डॉक्यूमेंट पर है, जो भी है दूध का दूध पानी का पानी होगा हुजूर के सामने, हमको उस पर कोई दिक्कत नहीं।
so exhibit 1 to 10 according to you were enough to prove that Zariuddin was the son of Firoza Khanam and Jumrati died issueless, यही आपको बोलना है ना,
issueless, और उसी के प्रॉपर्टी, और आबिद जो है, आबिद की माँ अलीमन है, और अलीमन जो है जैनुद्दीन की पत्नी है।
इसमें तो इसको क्या प्रूव करना है, तो एडमिटेड फैक्ट है, एडमिटेड फैक्ट को भी आप अपने जूनियर के कहने पे प्रूव करेंगे।
आबिद ने क्लेम कर रहा है कि मेरी माँ जुमराती है हुजूर,
नहीं अभी नहीं क्लेम कर रहा है कि उसकी माँ जुमराती है, आप नहीं क्लेम कर नहीं क्लेम कर रहा है, नहीं क्लेम कर रहा है सर, उनका रिटन स्टेटमेंट पेज नंबर 10 आप देखिए, आपकी जूनियर काउंसिल ने पढ़ा ही नहीं, वो इंस्ट्रक्शन दे रहे हैं, आप बहस कर रहे हैं, आप जरा देखिए पेज नंबर 2।
जी टेबल की बात यहाँ दिखाइए, जुमराती का बेटा जैनुद्दीन दिखला रहा है, जैनुद्दीन का बेटा
जुमराती का बेटा अबीद नहीं दिखा रहा है,
तो अबीद जैनुद्दीन का बेटा दिखा रहा है ना,
जैनुद्दीन का बेटा दिखा रहा है, तो जैनुद्दीन की माँ से मतलब है,
जैनुद्दीन की माँ जुमराती थी ही नहीं
सर, यही तो झगड़ा करना है, जैनुद्दीन की माँ जुमराती थी,
जैनुद्दीन की माँ जुमराती नहीं थी, यह तो केस है हम लोग का, स्पेसिफिक केस है, और उससे हम लोग को कहा है कि जैनुद्दीन वहाँ जो एग्जिबिट के बारे में डील कर रहे हैं कि जैनुद्दीन का जो लिखा हुआ है रिकॉर्ड्स ऑफ राइट्स में प्रॉपर्टीज के बारे में
The learned counsel for the parties have submitted that the relationship of Jainuddin, of Mirza Jainuddin with Firoza Khanum or Jumrati Khanum is based on documentary evidences placement. The learned counsel for the plaintiff has submitted that Exhibit 1 to 10 are clinching evidence to show that Jainuddin was son of Firoza Khanum and not Jumrati Khanum. However, he submits that he shall place the exhibits on the next date as he has to go through it. That's it. कब चाहिए?
हम खाली डॉक्यूमेंट सब देख लेंगे।
कब चाहिए? कब करेंगे?
कब किस दिन को समझ लीजिएगा, इसको बैठ के देखना होता है कोर्ट में। इंस्पेक्शन में नहीं आएगा, कोर्ट में रिकॉर्ड है।
कोई इंस्पेक्शन का काम नहीं है, सारा इंस्पेक्शन यहीं पे करिए, आराम से बैठ जाइए। हमारा एक आदमी रहेगा, आपसे रिकॉर्ड इंस्पेक्शन करना। उसके लिए परेशान होने का कोई काम नहीं।
किस देखिएगा, बैठिए ना, समय कोर्ट दे देखिएगा तो अगले मंडे को अखबार में कब बोलिए ना
Next budget.
ट्रेंड बोल रहे हैं 22 को रखिए।
22 को सिर्फ आपकी रिक्वेस्ट होगी और 22 को नहीं होगा, एकदम जस्ट वेकेशन के एक दिन पहले, उसके बाद आप लोग लीड होकर दौड़ते रहेंगे कोर्ट में।
अगले सप्ताह में रखिए ना इसको।
सर आप लोग इतना बिजी हैं क्या?
खाली एग्जामिन करना है, मैं बिजी हुजूर वकील का काम करना है, बिजी काहे के लिए रहे?
तो
कोर्ट
ये
में
रिकॉर्ड सारा आपके पास है, हम लोग देख रहे हैं।
इस वजह से हम एग्जामिन करेंगे खाली 17 या 18 हम इसको एग्जामिन करेंगे।
एग्जामिन कर लीजिए सर।
कोर्ट रिकॉर्ड में रहेगा, हम लोग मांगते हैं।
Post this case for further hearing on 17th को रखें honorable case. On 17th.
In the meantime,
Let this matter
that
be
question,
taken as part of.
if not formulated, then
No, we are not formulating it. We will formulate it on the next day.
फैक्ट पर जो हो जाएगा डिसाइड
No,
हो
it is okay. The learned
Is it
counsel for the
documentary
applicant
evidences?
has submitted that the learned first appellate court, while reversing the finding of the learned trial court that was Mirza Zainuddin Hussain was son of Bibi Jumrati Khanum, has committed perversity while holding that he was son of Firoza Khan.
नहीं।
क्या
यही ना होल्ड किया है।
Our contention was that the Jainuddin was son of Jumrati,
हाँ,
whereas
ये इन लोगों का केस है। ये तो कह रहे हैं कि ये कहते हैं कि जुमराती का बेटा जैनुद्दीन हुआ, जैनुद्दीन का बेटा आबिद हुआ, मेन डिफेंडेंट जो हो गया। ये है हम लोग का केस है कि वो है ही नहीं, ये दूसरे को जो है बिल्कुल थ्रो आउट करना चाहते हैं, अपना बेटा मान करके कि नहीं एब्सोल्यूट हम ही इनहेरिट करेंगे प्रॉपर्टी, जबकि फैक्ट इज अदरवाइज प्रूव। ऑब्लास्ट
Post for further hearing on 17th. Let this matter be taken as part. So, part of the. उनको chamber में बुलाना है। You come in the chamber.